They're all set. They're okay with that. Okay, good job. Yes. Yeah, I heard. Yeah. These are all. Okay. Thank you. No. This is not a situation but this is the first time.
Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is now open. Please be seated.
Give us a little extra room here. Up high. Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. It's my great privilege today to be sitting with Justices Henry, who's on my right, and Justice Hershfang, who's on my very left, remotely. For those of you who have appeared before us, much of what I'm going to say now will be repetition, but I'd like to go over a couple of the ground rules. Each side will have 15 minutes to argue. If you're dividing your time, we hope that you will have told us ahead of time so we can set the clock accordingly. We do not permit rebuttal, so don't reserve time for rebuttal argument. There's a timer on the podium that the green light will go on and it shows you, counts down backwards your 15 minutes. A minute and a half from the end of your time, the yellow light comes on, and that's a signal for you to try to, get in your final points before the red light goes off when your time is up. You may construct your argument any way you wish, but I will tell you that the panel will have read your briefs and the relevant portions of the record, and so that you don't need to feel that you have to tell us the background of your case. We already know the background of your case, so you can dive right into your arguments. With that, and for those of you who are here planning ahead for later in the morning, we're going to hear 3 cases, then take the morning break, and then come back for the 3 paired cases to be argued after the break. With that, I'm going to call the first case, which is case number 2022P0270, Christopher ALEKSOV versus AYESHA ALEKSOV, and I'm very sorry if I've mispronounced any of those names. And I understand, Attorney ALEKSOV, you are representing yourself, and we're ready to hear your argument whenever you are.
Chris ALEKSOV, and may it please the court, Judge.
You may have to speak up a little bit or adjust the microphone too.
Chris ALEKSOV, may it please the court. I'm here today to ask the court to overturn the probate court's ruling that the 2014 will of Ronald Kahn was not executed because it was not executed according to law, and it was a product of undue influence. And I want to first address the main issues regarding the lower court's ruling regarding the execution of the will. And it's important to start out by stating what was never at issue in this case. The genuineness of the signatures was never at issue. The issue of whether the will was a forgery was never an issue. There was no question it wasn't. There was never a question that Mr. Kahn did not sign the will in 2011 or 2014 And there
So
was no
in
evidence.
terms of the will, you're saying that an attorney did draw up the will, not you?
We don't,
You don't have,
We-
you
we
don't
don't
know
know.
the origin of it. Okay.
yes. And I mean, there was no evidence that I had any part in the procurement of the will or any part in the drafting of the will or executed any undue influence or any kind of undue pressure on Mr. Khan to execute his will. There was simply no evidence of that.
You
that was never-
indicated that you're his only grandson. Are you his only grandchild?
I'm not his only grandchild.
Okay.
And so because there were no
I'm
allegations.
going to ask you, because I think you just said something which you also said in your brief, which is that that Mr. Khan signed the document in 2014.
In 2011 and again in 2014.
Okay, so I'm going to look for that in the record.
Sure.
Would you please tell me the record page that shows his 2014
It
signature?
would be record appendix 1131.
All right, let me look at that.
So when you say that, are you saying he signed the last page in 2014?
That's correct, Judge. Which is permissible under section 2504C.
And was there 1121,
I believe it was 1131.
31?
So there's a signature on the attestation page.
Which is permitted by section 2504C.
Did any of the witnesses say they saw him sign that page?
Yes, they did.
Which witness?
Both Mr. Barnett, and again, I didn't note this in my brief because I didn't see it in the transcript, but I went back and saw that the other witness did state,
Oh, are you talking about the signature down at the bottom?
correct, Judge.
Okay, so did Ms. Reed say that she saw him sign that in her presence?
She equivocated on the answer. She first said she didn't, but later at record appendix 267, she does state that I don't think he knew what he was signing, implying that she saw him signing something.
Let's see. 267 is the gobbledygook page.
Yes. That some of we load a lot of our material onto an iPad, and for some reason, this appendix, when we loaded it, made many of the characters gobbledygook. We have the correct appendix on our bigger system, but
Sorry about that, Judge.
I know
it appeared.
it's on our end, I think.
I have it if it's
On
helpful.
Yeah, I do too. On page
Okay.
267, it doesn't say that she saw him sign.
She states, I don't think he knew what he was signing.
And you think that's on that? I don't know. She said, I don't think he knew what I signed.
I don't think he knew this was what he was signing.
What line?
Well,
do you know?
actually, you can't take it out of context. The whole answer is, I don't think he knew what I signed. I don't think he knew that this was what he was signing, that we were signing for him.
Sure.
Okay,
But when I read that, it's implying that she saw something being signed.
all right. So, what is the lens through which we are to view the evidence at this point?
The entire evidence, in terms of the facts of the law, the facts are viewed for the plainly wrong standard,
Clear error,
clear error.
right?
Sure.
And we look at the evidence in the light most favorable to the prevailing side.
That is true, Judge.
Yeah, so I don't know that this is really as strong as
Sure. But I would argue, Judge, that she did not need to know, or she did not necessarily need to see him sign. If she was in his presence while he was sitting there at a small table, 2 or 3 feet apart from each other. And the fact that she said she didn't see it doesn't necessarily mean that it didn't happen, where the other witness was able to testify equivocally to all of the requirements of the statute under 2502.
And what was there evidence, and if so, where, that your grandfather informed the 2 witnesses that this was his will?
Sure, Judge. And Mr. Barnett, the first witness to the will, stated that. He stated that Ronnie and Chris asked me to sign this will. And I asked him, did he acknowledge that this was his will to you? And he said, yes.
And how about Ms. Reed?
Ms. Reed did not did not say one
Right.
way or the other.
I mean, one of the problems I think for you is that it looks like the judge did not credit Mr. Barnett's testimony.
And my answer to that, Judge, if I may, is that her standard for what was required under the law, the burden the proponent must meet, was different than what is actually required. She believed that the witnesses were required to have made an observation about whether there was any undue influence, whether it was a voluntary signature, and whether, and I forget the exact word she used, under no constraints or undue influence. I
Well,
believe.
she found that one of the witnesses only signed as a witness due to coercion.
In her words, duress, Judge. And duress is a conclusion of law from the facts. And I have never found a case where the words, do you want to keep living here, has amounted to duress, especially when the whole premise behind that was that the witness didn't know what she was signing, so she asked a question. If you look at the page she signed, it's almost unbelievable. You would have to make at least a cursory scan of the page to figure out where to sign. And the page says under where she signed witness, above that it says attestation. And the first line of the actual attestation clause is this will, I believe it's something like this will signed by Ronald Kahn. So, I mean, it's while the judge did find that, it's not, this court isn't held by that. This court can look at the document and you know, see what it is for itself.
Okay, so if we were to accept the judge's finding on that point, what then? What happens to your argument?
It still doesn't reach the level of duress here, Judge.
No,
Duress
if
needs
we were
overcome
if we were to accept the judge's conclusion that Ms. Reed signed only under duress,
Sure, Judge.
then what then?
What then is that it doesn't change, it should change the outcome in this case because Mr. Kahn had no idea, and Mr. Reed knew that, and she had a duty to at least inform him of this alleged threat because it was Mr. Kahn's intent, Mr. Kahn's testimony and wishes that are issue here, not mine.
You're saying that Reed had a duty to inform him somewhat contemporaneously.
Yes, and
Where would that
immediately
duty come from?
from the fact that
Do
she
you have
signed.
a legal authority that would support that duty?
I would, and
What is it?
It's the case of Genovese v. Genovese, where they say an admission on an admission over. Let me pull out the exact language, Judge. I don't want to misquote it. It says there's a longstanding rule that a penalty for an omission to perform a duty on the part of a witness, so it implies a duty that a witness has when signing a will, will not be visited after the death of the testator, basically when you can no longer do anything about it. So it looks at the testator's testimony intent when they comply with the statute and believe they comply with the statute, not what a third party, you know, did or did not do. If you were to accept the judge's finding that the words, do you want to keep living here, were duress when the witness listed a New York address and she claimed to be the tenant of the building. So
let's assume for the moment that the witness did list the wrong address. Is that, and I take it that the testator would have known that was the wrong address. Is that some sort of hint that perhaps she's signaling that she did not sign this of her own free will?
I don't think there's an inference that can be drawn from that. I think that
why not? Then the testator knows that what she did wasn't true.
I suppose he could have asked the question too. Do you plan to keep living here as a tenant if you're listing an address in New York? I mean, there are a lot of other possibilities it could be. The fact is that he didn't.
Right, but if we look at the evidence in the light most favorable to that this was under duress, then the interpretation of her putting the wrong address is that she's indicating something is not true. She's doing something to say this signature is not valid.
I don't necessarily think that's I understand where you're coming from, Judge, but it is also there are other possibilities that and I don't think that makes a difference. I mean, there's no requirement under the law that you list an address. It's simply that you sign your name under the word witness or above the word witness, or it doesn't have to be the word witness. there are good reasons why she could have done that or bad reasons, and I can't and I don't see them affecting what is required underneath the statute in order to have a valid will.
What do you say are the requirements? The requirements that needed to be met?
Number one, since the probate code of 2012 made the requirements a lot less stringent than they used to be. You need a will in writing signed by the testator or on the testator's behalf by his conscious presence. And then 2 witnesses who either saw the testator sign, saw him acknowledge the will, or within a reasonable time after he did so. In this case.
Right. And so it needs to be both of the witnesses.
Sure.
Right. It can't just be, it can't be that you need 2 signatures, but only one of those witnesses met the requirements of the statute.
But there can be implicit acknowledgement, which this court has said before. And basically the circumstances of sitting around a small circular table, 2 or 3 apart from each other while you're passing around a document.
While everyone's drinking and having a party.
Sure, but there was no,
because we have to take the evidence in the light
sure,
most favorable to the prevailing
but
side.
there has to be evidence that there was actual a party or the people were
There
intoxicated.
was.
It was 2 or 3 people drinking a drink or 2 in the afternoon. I don't, even if you take that
The
to the extreme,
judge-
that's still a party.
Okay. There was evidence which the judge credited that the circumstances of the witnessing of this document occurred while everyone was sitting around drinking and after they had been drinking for an hour. To put it mildly, those are not the customary circumstances under which a will is executed.
And I understand.
So the judge drew certain inferences from those circumstances. As long as those inferences are reasonable, why aren't we bound by them?
Because there's no requirement that you do or do not. I agree that it's not the usual circumstance, but as long as the statute is met and the legal requirements of the statute are met, there was no allegation that anybody was lacked capacity or didn't know what they were doing. At any time during any part of this of the entire process, from day one, from the affidavit of objections to the proposed findings of fact or rulings of law, there was no allegation that Mr. Khan was drunk, that he didn't know what he was doing.
But it's less about him at this point, right? And more about, I assume you guys can hear me okay. This is all sort of novel.
Yes.
Thank you.
I didn't hear what, can you?
Well, it's okay. I'm not to my question yet. Assume it's not about what Mr. Khan understood, right? And at least my hearing of Justice Wolohojian's questions goes to the adequacy of the 2 witnesses' signatures. And here the question has to do with our respect under the law for the factual findings made by the trial court about the testimony of Ms. Reed about her signature. And so, you know, as Justice Wolohojian has said, we are, unless there's something wrong with that, unless it is unreasonable or clear error, we are stuck with it, which leads me to my actual question. That was all just testing the sound system, which is, what is your position on the legal question of if we were to find that on the facts as found by the judge, which were not clearly erroneous, the, call it 2011, 2014 will was not properly executed, do we need to reach the undue influence question as it pertains to that will?
Yes, Judge, and I think you do, because of the subsidiary findings that the judge made regarding a civil case that the parties have going on. And I would request that the court do that because there was no evidence of any undue influence, and the burden was on the objector to provide evidence. There was no notice of it. There was no discussion of it at any point, and it only came up a year after the trial finished.
Wait, you're saying that I want to make this distinguished. Do we need to reach the issue of undue influence to resolve this case? Because you're indicating there's some other litigation between you, but we're asking about this case.
Sure. And I would say yes, Judge, because of the subsidiary findings the judge made regarding later deeds that were executed, where she said it was a pattern of undue influence, that would prejudice my case greatly, as it was brought over for a preclusive effect in the civil litigation.
No, I think you've misunderstood the question. Assume that we determined that the procedural requirements with respect to the execution of the 2011, 2014 will were not met. Therefore, it was not a will. It's not a valid will. Do we then need to reach in order to resolve this appeal?
No, Judge, you
the
don't.
question of undue influence?
You don't, but I would request that the court does.
Because you would like some collateral benefit from that.
I would just like, because I never had a chance to litigate it, and I would have if I had any indication that it was an issue.
Okay, I think I understand. Let me see if there are any further questions. That's probably not going to be it from you. No. All right. Thank you very much.
Good morning. May it please the court. After a 4-day trial, the judge made a very detailed finding of fact. The issues of undue influence were certainly before the court. They were litigated by the parties. There was no self-proving affidavit signed as required by Chapter 190B, Section 2-504. As a result, the benefactor of the will, who was also there as essentially the quarterback of this 2014 signing of the 2011 will, has the burden of proof. Clary shifts the burden to Mr. ALEKSOV, Attorney ALEKSOV, and as such, we're of the position that the judge got it right, that it's a clear, articulated opinion. The trial judge took almost a year to draft it.
I didn't see any notice that the question of undue influence with respect to the 2011, 2014 document was going to be tried. Can you point to me the pages in the record where we would find that notice?
So I did look in anticipation of today, and the words undue influence are not actually cited in the affidavit of objections. However, the affidavit of objections are all based upon that very issue of
So show me. And what about, well, just, I think, let's see. I mean, that, right? It's going to say what it's going to say. In your client's affidavit of instructions, of objections, sorry. I didn't see the question of undue influence raised.
it is not raised
Okay, so,
specifically.
well, all right, so then you would acknowledge that due process requires that a person be notified what's going to be at issue in a trial. So as long as that's satisfied, great. But can you show me in the record what satisfied it in this case?
I cannot. I would say it would be taken as the affidavit as a whole. And I would also argue, Your Honor, that the 2019 will that would have benefited Attorney ALEKSOV's mother was also contested on the same grounds by Attorney ALEKSOV of undue influence. So,
But undue influence was very clear in that affidavit of objections, right?
it was, but under Section 2-504, because there's no self-proven affidavit, the statute itself requires that the burden be met by Attorney ALEKSOV, that there is no undue unnatural disposition, and that Mr. Khan was not susceptible. So that in and of itself, under the statute, is required by Attorney ALEKSOV.
Well, I mean, you're going to have to show me that language in 2-504. all I see there is that what's required for a will to be a self-proved will. And then I think if you don't satisfy 2-504, then we're in the realm of 2-502.
That the intent of the document, and that would be 2-502,
Exactly.
section B, requires that the intent that the document constitute the testator's will can be established by extrinsic
Sure.
evidence.
But I don't, I mean, I think these two sections appear to me have to do with how you establish that a particular document is a will. Not every document that says will on the top of it is a will. We have formal requirements for a will. It doesn't, the question of undue influence is not
Well,
presented by these two statutes.
I don't necessarily think that this court needs to actually get there, because the 2014 will itself does not meet the very requirements of 502, which is Linda Reed did not witness this will. The will lacks two witnesses. The fact that the parties.
Well, but let's pause on that, because what we are trying to do is carry out the testator's intent. And why should we allow a witness to stay silent and not report, maybe not report to the testator, but report to a court or to the police that this happened? Why can they just not say a word? And then assuming for the moment it was the testator's intent, we've just scuttled that and they're dead. They can't do anything about it. Whereas if she had given someone notice, then somebody could address it.
Well, one, they were drinking. Two, there was a threat, the finding of fact, there was a threat by Attorney ALEKSOV himself stating, do you like living here? Do you want to live here? That's a thinly veiled threat, frankly.
But let's assume it is a threat. At some point, why can she just continue to not do anything about it?
What's the duty of a witness? To come forward. I don't believe that the witness would have a duty to put her housing at risk. Her friends are
Well,
there, her drinking partners.
if the balance is between somebody who is vulnerable and who, may have their last wishes literally threatened versus something that can be corrected, particularly if she reports it to the police or a court and then gets protection from the person who made the threat. The balance here is that he can't do anything now. And she has options, and she's now taken away his chance to make sure that his worldly possessions and money go where he wants them.
But Linda Reed doesn't know what's in that will. Linda Reed's only given the last
But
page.
what she knows is that this isn't true, that she hasn't done what she is supposed to do as a witness.
She doesn't know what she has to do as a witness. She doesn't know what's inside the will. She doesn't know if she doesn't know anything about what's inside the will. She was
Well,
given
but she
just the
knows
last
she
page.
feels threatened, right? So she knows something nefarious is afoot. That is her belief when she signs this, thinking she's being forced to sign this.
Well, she had no other choice but to sign it. Yes, she doesn't necessarily know what's inside the content of this will, though. What was it that Attorney ALEKSOV was taking half of the estate? Was it that Attorney ALEKSOV was taking the whole estate?
Well,
She
I'm
doesn't
not
know
sure
that.
why it matters. What she knows is that he threatened her. So I would say even a child could figure out that maybe he was getting something he shouldn't be getting, and that is not okay. And that perhaps someone who is an upstanding person would do something, that if you know something is not right, you do something about it. And she didn't do anything. And now this man is deceased, and we don't know if this could have been corrected.
But she did do something about it. She came, she testified at trial. She
Right, but maybe she just hates him. We have no idea.
Well, but the trial judge had the opportunity to hear her, to see her, to hear her testimony. Attorney ALEKSOV had the opportunity to cross-examine this witness. There was an opportunity there to
At a
inquire
time when
further.
the testator can't then take a different course of action. And so we leave him with the will that the state has written for anyone who doesn't have a will. And we don't know if that is what he wanted.
But we don't know if he knew what he wanted, that because he was susceptible at that moment in time. He was drinking alcohol. We don't have any details of what was signed in 2011, who was present, because there were no witnesses in 2011. He's simply in 2014 at a table where they're consuming alcohol. He's executing a rather re-attestation of the will, and the witnesses are drinking. And it's all being quarterbacked by Attorney ALEKSOV. And he pulls the will out of a drawer. No one knows the origin of where this will even came from, or if Mr. Khan even knew the contents. Again, the burden is on Attorney ALEKSOV under Clary v. Clary to show that this was not a product of a person who was susceptible, was not an unnatural disposition. He didn't do that. Because he didn't take the very basic steps. I think the trial judge called it an affront to the estate planning process. This is a member of the bar that is quarterbacking this. This isn't Joe Citizen that's bringing this will out at this table. That this is somebody that's taken an oath to this Commonwealth that they're going to uphold the laws, and for that person to take a will while people are drinking from 2011 and 2014 to put it down in front and only the last page and say, sign this or else, that's a problem.
So the other pages weren't present?
They were not present. Linda Reed testified that they weren't present. I believe it was 252 or 254 of her testimony that she was only given that last page.
So are you saying that take this outside the facts of this case, just as a general proposition, that a proponent of a will, when they present the will for probate, that they have an obligation in all cases to prove that the will was not the product of undue influence?
No, because
Okay.
a self-proving affidavit would have.
Okay,
Solve that.
so what is your legal authority for the proposition that if there is no affidavit that conforms to 2-504, in other words, it's not a self-proving will, that there's then an obligation to prove that the will is not the product of undue influence?
It's not that it's product of undue influence, but that it was properly executed. That it was
Okay, so
properly
but
witnessed.
I'm not talking about execution right now, because I'm trying to go back to my questions about whether there was proper notice about whether the 2011-2014 document was the product of undue influence. So if you don't have an obligation as the proponent in all cases to prove the absence of undue influence, then it seems to me there needs to be notice at some point given that undue influence is at play in the case, correct?
The issue here, though, would be that Attorney ALEKSOV was the benefactor of this will. So because of that, he's got a conflict of interest inherent. And
I'm not talking about the validity of the finding that there was undue influence. I'm trying to get a handle on whether notice was required.
Because
Undue influence with respect to the first document was going to be tried. And there was, as I understand from your answers earlier, there was no explicit notice. The objections, your client's objections, did not say anything about undue influence. So I'm trying to understand whether A, notice was required. And based on what you've said so far, I think the answer to that has to be yes. And 2, because you can't just keep pointing to section 2-504. That's not going to do it.
no, but if we look at the 4 days of testimony that the judge was basing this off of.
I know. I'm not talking about the validity of the finding of undue influence. I'm talking about notice that issue was going to be tried. If you can help me, that would be helpful.
I think under Messina, which is cited by Attorney ALEKSOV, that it which states the issue is not raised or litigated by the parties. Here, it was litigated by the parties.
Was there notice that it was going to be litigated?
There was not explicit notice, but if you take the affidavit as a whole, there's no other conclusion that you could find based on all of the sworn statements by AYESHA ALEKSOV that can only lead to the conclusion that this was a case that was challenging the disposition,
Okay, so let's just look at the affidavit. So if we're looking at RA 80, it says that Christopher ALEKSOV forced or misled my dad. Is that enough by itself or in combination with something else? That's paragraph 6.
it is.
Okay, and then it says elsewhere, it says that his father, well, Linda Reed, she says, was forced to sign her name and that it wasn't what the father wished to do to bypass the daughter. And then perhaps most damning on paragraph 26, it says Christopher has been scheming and plotting to disinherit me from my own father's estate. Is that specific enough or is that?
That is specific enough. I
And
think
can
a
you
reasonable inference can be
articulate
drawn.
why that is, why that's enough to tell him, to give him notice that undue influence is the issue?
Because it's in the affidavit, it's stating, this is not what my father wanted. It raises the very issue of an unnatural disposition. And that puts it front and center. It was front and center in the trial of whether or not this was Ronald Kahn's wishes. And because of that, Attorney ALEKSOV certainly had notice and the opportunity on each of these witnesses to cross-examine these witnesses and to argue the substance that this was what my grandfather wanted.
Okay, we're gonna have to leave it there unless there are other questions. Hey, look, no. All right, thank you. Thank
Thank you
you
very much.
both. The case is submitted. The next case on the list is 2022 P0122 Elsie Fetterman versus Kevin Michelson. Attorney Jacobson, we're ready whenever you are.
Thank you, Judge. Trying to save paper with an electronic record.
Take your time.
Good morning, and may it please the court. Jonas Jacobson here for Kevin Michelson. I'm here today a little awkwardly as a total opponent of arbitration. I think that there's something really screwy about giving private parties who may have an incentive to secure further work as arbitrators such broad right to make decisions in arbitration actions. And, you know, as neutrals who try very hard, true neutrals who try very hard, I wouldn't be surprised if some members of this panel share my view to a certain extent. But that is exactly why the Massachusetts Arbitration Act is written the way that it is. The point of the act is to give the parties the opportunity to have their case heard by call it a judge of their choosing, and the actions of any judge with respect to a request for arbitration are extremely limited. They include.
So, but I want to get some very specifics nailed down. Is it undisputed your client did not pay his half of the arbitrator's fee?
That's undisputed.
That is undisputed. And I know there are issues about why, but is it undisputed he did not attend?
That is not undisputed. There is, so as I say in my brief, he's a Gmail user. And he's an auto mechanic, so he's not.
No, I understand there's issue about he didn't think he had a link and all of that, but the arbitration was convened and he did not appear. There, I know you want to argue about why he didn't appear, but he did not actually appear. That is undisputed.
That is undisputed. He did not actually
Okay.
appear. That's correct.
Okay. So you have argued that what should have happened is that Ms. Fetterman should have presented her case to the arbitrator. But the problem with that is that the arbitrator didn't get her full fee. So if the arbitrator said, I didn't get paid, so I'm not doing this, then what happens?
She just makes an award for the Miss Fetterman.
Didn't get paid.
Miss Fetterman pays the fee. I think there's a
So
sixth.
whoa. Okay, so what's your authority that you can make Ms. Fetterman pay money to do what your client should have done?
Sure, and I cite in my brief a couple of different cases from admittedly mere persuasive authority from other jurisdictions that, for example, JPD Inc. v. Chronomed Holdings, payment of fees is a procedural condition precedent that the trial court should not review. So I think what would happen in that circumstance is that the arbitrator could take two possible actions. First, the arbitrator could accept the full fee from Miss Fetterman and award the full fees, which she would probably do anyway if Miss Fetterman were to prevail, to Miss Fetterman, or she could rule on the arbitration award and then institute private collection proceedings for the other half. But in any event, it wasn't the judge's responsibility to get involved with that.
Let me, so I want to make sure I have the procedural history correct. The first thing that happens is the plaintiff files a suit. The defendant, your client, files a motion to dismiss, which in essence is a motion to compel arbitration. And
Can I stop you there?
sure,
It is not a motion to compel arbitration. Instead, he files a motion because this was the question in this case is when the principal balance on the note was due. And he'd been paying interest only payments according to the agreement. So his motion to dismiss was like, hey, you have no reason to sue me. I'm making payments.
Mm-hmm.
And that's, substantively what his defense is. What happened is Miss Fetterman filed an opposition to his motion to dismiss that referenced the arbitration agreement. The judge said, wait a minute, there's an arbitration agreement. I'm going to construe your opposition as a motion to compel arbitration and compel binding arbitration.
right. And nobody objects to that. In fact, there's an order that's entered and then the parties proceed according to that. And no one's raised on this appeal that ordering arbitration was incorrect. So in that initial order, so that just seems to me that we accept it. So they're ordered to arbitration.
So
And the judge in that order says you need to institute arbitration within 60 days and use the Hampshire County or Hampden County, I don't remember, arbitration panel, whatever. There's an order. And the parties go off and they don't manage to meet the 60-day requirement. They come back to court and file a joint motion for relief from the 60-day requirement, correct?
I think that's correct. Yeah.
Right. And the judge allows that and gives them another time limit. There's evidence that that time limit still doesn't get met, correct?
Yep.
And there's evidence that the judge could credit that the reason for that was to be laid at your client's door.
Sure.
And then there's a motion to compel arbitration that the plaintiff files.
Mhm.
So far, procedurally, I see no error. You're not claiming any error up until this point, correct?
So no error was raised below.
And
so I
no
don't- I'm
errors
not-
raised now.
I'm not troubling you to argue it now,
Right,
but I mean, obviously I
okay.
do see some problems.
So then we have an order that the judge enters in response to the motion to compel arbitration. And that order allows the motion to compel and says it is ordered that the parties submit, participate, and complete arbitration by April 5th, 2021. Parties are advised that if the court finds that either avoids arbitration without good cause, the court will entertain the other party's motion for default judgment and conduct an evidentiary hearing on the issue of damages. Now, that order is the order, I believe, that's at issue in this case, right?
I think so, yeah.
Judge certainly had the authority to enter such an order.
I'm not sure that I agree with that.
All right, what's your legal basis?
251 Section 5 gives the judge the authority to order the arbitrator to proceed forthwith, but doesn't appear to give the court the authority to order the parties to proceed forthwith. I believe that the way the Arbitration Act is structured is to give the judge in the first instance the power to compel arbitration. That is to say, get out of the court. And then in the final instance to say, yes, this arbitration award is valid, or no, it isn't.
Sure,
And then
okay.
everything in the
Is
intervening
there a
period.
case where we've construed the statute in the way that you're advocating? Because I'd like a citation.
With respect to Section
The
5.
argument you just made. Do you have a case that says that,
That the court can order the arbitration to
but
proceed.
can't order the parties to
Get on with their business.
proceed in a certain amount of time?
I think that actually, like, the judge's actions in this case were so out of bounds that there is no
Wait,
authority.
okay, what, first of all, if the arbitrator hasn't been paid, what authority does, I think slavery's been outlawed in this country, and I don't think judges can just order third parties who are not parties before a court to be a judge in a private arbitration. What's the authority where they can say, whether you're getting paid or not, you are going to arbitrate this?
I think it's in Section 5. And they could
You
say,
think the legislature has said that the judge can order the parties to pick a person, and that whether that person gets paid or not, they have to work?
I think that once the arbitrator accepts the assignment, the arbitrator takes on certain responsibilities. I think the arbitrator can say, I will not sign up as the arbitrator until I receive my fee. I know that, I've
Okay,
personally
so the
scheduled
arbitrator
arbitrators.
has
Arbitrator
to,
said that,
the arbitrator has to accept the assignment.
if the so I think there was some back and forth between, because Judge Josephson had worked with Judge Carey in Hampshire County, I think, in the past. And so I think that there was some connection between the two of them. I don't know that it was appropriate for the judge to order them to use a specific arbitrator. I don't, like, just based on the contract. Now, if the contract had said you're to go with the Hampshire County Bar Association arbitrator, then he could do that. I think his decision to pick.
All right, I have to say, speaking for myself, I don't find all that helpful arguments that just say, I think. For me, legal authority is very helpful. So I understand that you're arguing that you're relying on the general arbitration statute that allows a judge to appoint an arbitrator. Do you have anything else that supports the notion that the judge could not enter the order that the judge entered on February 4th, 2021?
I think the cases in my brief are
Which one?
fairly, all sort of stand for the proposition. You've got Town of Danvers v. Wexler Construction. That's 12 Mass Ave Court 160.
What happened in that case?
The appeals court said that
What were the facts?
I don't have the facts for you at the moment.
Yeah. So what I'm wondering is if you have a case where the parties are ordered to arbitration, there's an arbitration provision in the contract, they're suing on a contract, the judge says, yes, I'm ordering you to go to arbitration. And then there's a party that one could find was not willing to participate in arbitration, although ordered to do so. Do you have any case that says the judge cannot then do anything at all? Because that's what your argument is. Your argument is that once there's an initial, I believe your argument is, once there's an initial order to arbitration, the judge was disempowered to do anything, regardless of what happened next.
So I think that the judge, again, under Section 5, could order the arbitrator to make an award. And I think that under 251, I think it's Section 12, the arbitrator could proceed in the absence of the defaulting party and take evidence from the arbitration applicant. But I, again, don't have a case because this is such an unusual situation. And believe me,
Because most parties participate in arbitration when they're required to.
or the arbitrator. So in this case, you can read in the arbitrator's decision that she was aware of the court's order. So she didn't proceed as she probably ought to have, which is to say, look, I think Mr. Michelson isn't here. And because he isn't here, I'm going to take all the evidence from Ms. Fetterman. Ms. Fetterman presents her evidence. Presumably that's sufficient from the arbitrator's perspective to make an award in her favor. And Mr. Michelson loses. That award then goes before the judge. The judge says, look, you weren't there. And there's a hearing on whether to vacate the award. He probably loses that hearing, and then the case is over. But because he made this order that she kind of interacted with, it changed the ordinary procedures. That's why I say it's just such an unusual situation.
So your opponent argues that there's a waiver issue here, that these arguments were not made below. What do you say to that?
I addressed that in the reply. There were a number of times where Mr. Gallant raised those issues, both in the default hearing and in his briefing and in his argument. And I cite those in the reply brief because I anticipated that the court would have those specific questions. I want to point out that the judge in this case is, I know most Superior Court judges ride the circuit. The judge in this case is a frequently sits in Hampshire County. So an amount of delicatesse is required on the part of the of attorneys appearing before him who regularly appear in that court. I think that's the reason for the circuit, but I also understand that that's a court that's very far away from where most of the judges on the Superior Court live.
Are you challenging any of the findings as clearly erroneous?
The judge's findings?
Correct.
I'm challenging. I don't think we reached that analysis. I'm challenging the judge's basis to make those findings. You can't hold somebody in contempt after Birchall without clear and convincing evidence, without giving them the opportunity to answer, without doing follow those procedural steps. I mean, if the
So
court's
where is that argument preserved in the record below?
I believe it's preserved in Mr. Gallant's opposition to the motion for attorney's fees, and elsewhere in his arguments.
Can I just ask a quick question about the record in this case? My understanding, and please correct me if I'm wrong, is that your client filed proposed findings of fact and conclusions of law before the court after the arbitration failed to reach a conclusion. Am I right about that?
That's right. He did his best not to have the default judgment enter, but I mean, I think that was also a little odd. He's saying it's a default judgment, and then the court's taking findings as to liability in that hearing. There's no questions as to
No, on damages.
Well,
That's not odd.
No, I'm saying that the court is also asking questions about liability. I mean, there's significant questioning about that at the
But that would bear on damages, would it not? If there was no liability,
well,
then there'd be no damages.
Well, in a default hearing, the facts of the complaint are presumed to be true. So you wouldn't really need to do
All right,
that.
so then whatever error there might have been would have been to your client's benefit.
No, I wouldn't say that
She was
because
looking at liability too.
I wouldn't say that because he went ahead and entered attorney's fees after the fact, which he also had no right to do. And clearly just looking, I mean, it could have almost been done under 55B1 if it were going to be a default, which is the, single damages by the clerk. I mean, this is a promissory note, just like, here's the number and there's nothing more to say about it. If in fact he was in default. I mean, I guess there was this question, the case was about, was this 2-year period reasonable? Yes or no? And the answer that Ms. Fetterman saying is no, and what Mr. Michelson is saying is yes, and there's a debate about that. But if he doesn't get an opportunity to discuss that, then he would lose on that point.
Let me see.
I just wanted to follow up. Sorry, my question was actually directed at a different point, which was a jurisdictional point. If I hear you correctly, Attorney Jacobson, you're arguing that basically the court had been divested of jurisdiction by the referral to the arbitrator. And I was wondering what effect, if any, your client's filings with the Superior Court had on your jurisdictional argument. It seems to me that's evidence of submitting to the jurisdiction of the court.
So I don't think that arbitration is jurisdictional. I don't think it's a question of the court's jurisdiction. I think it's a question of the court's abuse of discretion. And I think it's important to focus in on that, because the court didn't have a statutory basis to do what it did, but there is case law all over the place that I didn't even bother citing that arbitration is non-jurisdictional.
Let me see if there are any other questions.
Did your client file something with the Superior Court saying that he did not want to arbitrate?
He probably did. I mean, he didn't, he filed a lot of things. I think his lawyers withdrew, and he was, from his perspective, he was making the payments. Why am I being sued? He was very frustrated with the process. He felt like everybody was against him. So did he comport himself as I would have had him comport himself? No, and that's probably what makes this case difficult, because I think it's pretty clear that the judge overstepped himself. But if there are no more questions, I did want to close by pointing out that although I'm an opponent.
Your time is up.
Oh.
So we're going to have to leave it there. Thank you.
Could I just finish my thought?
We've already gone over on your time. Thank you.
Good morning, and may it please the court, Ryan O'Hara of Bacon Wilson, on behalf of ELSIE FETTERMAN in this matter. Ms. Fetterman is here in the courtroom today behind me. I think my brother hit the nail on the head in this case when he said he's here as a total opponent of arbitration, because so is Mr. Michelson. And that's exactly what the record in this case, the actual record in this case, Your Honors, when you go through it, demonstrates. Let's take Mr. Michelson's words from October, his own words, which were in evidence before the judge when he made these factual findings. I would never give up my right to a trial. This is when he's saying he didn't realize arbitration was binding and would never submit to it. I'm not willing to waive a full trial. Cancel the arbitration. That's in October.
Well, did the parties?
Sorry, go ahead, Judge Henry.
Did the parties have the right to agree after the court filing that to not participate in arbitration?
Absolutely, Judge, because I think what is most important here is to look at what Judge Carey was dealing with in the total context of this case. And this isn't a situation where some parties were privately handling arbitration outside of court process, and one party went running to a Superior Court judge and said, hey, step in, we need you to get involved. This is a case that originated in the Superior Court. Contrary to the argument this morning, it was Mr. Michelson that first raised the issue of arbitration. I'll agree it wasn't a request explicitly to have the matter arbitrated, because he was claiming, as he had at all times, I have no liability. But that's at page 23 of the record. You can see in his original motion to dismiss where Mr. Michelson points out to the court, hey, look, there's an arbitration clause here in the contract that, as a matter of fact found by the court, Mr. Michelson authored. So that's how the original arbitration issue arises. In the opposition, Ms. Fetterman seized on that and asked the court, instead of dismissal then, to send it to arbitration. That's what happened.
At that point, the defendant was represented by counsel when he made that argument, right? What I see is that an argument that says they entered into a specific in no unclear terms and inconspicuous type style that they would submit any disputes to arbitration, and with the intention that arbitration would be the sole method of resolving disputes arising from the contract.
That's exactly right. And that was the first of defendants' 4 attorneys, 3 of record at the trial level. So that's the defendant's attorney writing that. At that point, it gets referred to arbitration, and it's supposed to happen within 60 days. And not to belabor the record, but what Judge Carey found and is undisputed is Ms. Fetterman immediately said, great, they've referred us to the Hampden County Bar Association Mediation Service. Here's some arbitrators we'd be comfortable with. Get back to us. Never gets back until the 60th day saying, oh, I don't have it yet. I haven't been able to get in touch with my client. Let's continue it. Continued by agreement. 118 days into the whole from the order is the first time Mr. Michelson provides a list of arbitrators. And contrary to the idea that this
I think
arbitrator.
we know the sequence of events. As I see the defendant's argument, and I may be missing it, but this is what I understand him to be arguing, is that once the judge ordered the parties to arbitration, essentially the judge could not do anything other than wait for the arbitrator to act and then confirm or reject the arbitrator's award. That's what I understand his argument to be. Do you have any case that's similar to the one we've got on the facts, where a judge orders the parties to arbitration, one party willfully refuses to participate in the arbitration, and then the judge then enforces an order that the judge had entered, saying that in those circumstances, the judge would entertain a motion for default judgment?
Those exact facts, Judge Wolohojian, no. And I think
anything close?
I think yes. And I think that there's a case out of this court, the Samsill decision. It's a 128, well, maybe 128, maybe the new.
Yeah,
phrasing
it's
of it.
23. We know.
What's the name of the case?
That's 100 Mass Appeals Court 1115. And what happened in that case was
Sorry,
Samsill is one of the parties,
Samsill.
and it's spelled SAMSILL. And what happened there, to Judge Henry's point in the appellant's argument, is slightly different facts, but a case that was supposed to go to AAA arbitration. One party didn't pay the fee and then tried to claim that they nonetheless should be able to proceed and it should be referred to arbitration and the Superior Court should have no power. And what this court found was the failure to pay the fee, standing alone, forget these other issues, was a waiver of the arbitration right. Here, Judge Carey was dealing with so much more. And I agree with you, Judge Wolohojian, as to what the appellant's argument is. It's that if a Superior Court or any trial judge refers a case to arbitration,
Then it's out of their hands.
forever until an arbitrator makes a decision. And the court identified today one problem with that. It's what if the arbitrator says, I'm not being paid, I'm not going forward with my work. But here, what happened on the actual day of the arbitration and the days leading up to it in March, Mr. Michelson was threatening the bar association that was administering this. He was asking them for their insurance information. He was threatening to file a suit. This was all known to the arbitrator.
Right, but here we don't have the arbitrator saying, I'm not going forward because I'm not getting paid. She in fact opened the arbitration, even though she hadn't been paid. So his argument is that either Ms. Fetterman should have paid the fee, which was, I'll say, only $700, although I'm not sure you can compel someone to do that, or that the arbitrator should have just ruled on the award and then instituted collections actions. And I'm not sure that any arbitrator would want to spend the possibly hundreds of hours to get the $700 fee. But that's his argument, whether it's a good one or not. I'd like to hear from you about what's wrong with his argument.
I think there's a lot wrong with that argument. And one is that interprets the Arbitration Act to divest the Superior Court of all of its inherent authority to manage cases that are sitting on its docket as this one.
I guess the question is, does it? Because couldn't the Superior Court have said, imposing a fine on you for every day you're not going to arbitration, or I'm ordering you to pay and I'll hold you in contempt if you don't?
The question isn't just what the Superior Court could have done. It's what does it have the authority to do and what was within its discretion to do on the undisputed facts found as to Mr. Michelson's conduct with regard to this arbitration. So Judge, perhaps that is a sanction somebody could have done or an order that could have been made. Here, though, as ultimately found by the judge and as dealt with before this third time trying to arbitrate the case had been ordered, that Mr. Michelson had, as found by the judge and not contested as a finding of clear error, in bad faith, avoided the first arbitration, lying to the retired Superior Court judge, to opposing counsel, and to his own counsel that he was sick, and never tried to, with COVID, and never tried to introduce any evidence about that further. The judge found that he lied again when in October, he unilaterally canceled the arbitration, claiming he had.
We understand your argument that he's a liar and a scoundrel who's engaged in delay. That we understand your point. But what we're trying to get at, though, is, like, for example, could the arbitrator have had the option of hearing Ms. Fetterman's damages claim or liability claim and made findings
If the arbitrator chose to do so, I think they could have. Judge.
without being paid? Okay.
Yeah.
And could the judge here have done something to, short of actually holding, say, holding him in default and damages hearing, but could the judge have done something short of that, like a further order to compel?
The judge could have, but the judge had to consider on all of the facts before him what the appropriate remedy on these facts was. So the judge well could have considered, based on the factual findings ultimately made, and this was the point I was trying to make, not to argue that these facts happened. That's, at this stage, established. Those are the facts. So then on those facts, what was the appropriate thing for the judge to do? And an experienced Superior Court judge, Judge Carey, has not been doing this for 2 years. Judge Carey has been doing this for a long time. And when faced with
No, but that doesn't really, that's not a factor we take into account. I think it seems to me that as long as the order, I forget the date, the February 2021 order was a valid order, and there was no argument made, I don't think, or at least preserved that it wasn't, then it seems to me that the parties were on notice of what would happen if they failed to participate in the arbitration. And the judge was entitled, always has authority to enforce its own, the court always has authority to enforce its own orders. So, and I think perhaps, was there any I guess my question to you is, was there a preserved objection to the court's authority to enter the February 2021 order?
No, Your Honor.
What was the basis for the opposition to the motion to compel arbitration?
The basis to the motion to compel arbitration, the opposition to it, to the extent there really was an opposition, and all the pleadings are in the record, Judge, and that's why we provided them to you, because there is a big factual background here that requires you to look at it closely. But as best I can recall, and that was Mr. Michelson's at that point, second attorney of record.
Is that the one that's on page 50 of the appendix?
So page 50 is Mr. Michelson's own pleading, where he's providing his emails back and forth with his attorney. And the one he submitted is saying, I don't believe I have to arbitrate. That's what he was arguing. I want a full trial. So at that time, Mrs. Fetterman was looking to still compel arbitration. That was the basis for the opposition, not an idea that the order itself would somehow be unlawful. And I think, Judge Wolohojian, just to go back to where you started that question, if that's where this case ends, I agree with you totally that is the end. If that's a lawful order, then everything that follows is not even really meaningfully challenged at this stage. The question is really whether Mr. Michelson had this inviolable right to have this arbitration, despite his own conduct, despite the fact that there hadn't been payment, despite the fact that the arbitrator and the Bar Association could well have reason to believe that if the arbitrator made the decision, they're getting individually sued in this case, then on all of those facts, he still had this inviolable right to have it. If that's the argument, then it is somewhat different. And I would point the court there, because I think it's important, even though Judge Carey didn't explicitly find that based on the Bashara case, I'm finding the defendant has waived any right to arbitration, and then I'm issuing sanctions for this other conduct I'm finding. That's very obviously from his decision. It's 13 pages, it's well-reasoned, it's supported by extensive citation to the record and to the law. And what he clearly is finding is that Mr. Michelson by his conduct has waived arbitration. And that's something that this court on review, within its longstanding case law to uphold the trial judge for any reason apparent on the record, could also find, because what those
Well, if
cases,
he found, I don't know how much that's going to help you though, because if he had found that the defendant had waived arbitration, doesn't that just leave you back with a complaint in Superior Court that needs to be tried? How does that get you a default?
no, because we still have the issue from Wong v. Liu, the Hatch case, Crocker, about the Superior Court's ability to make sure litigants comply with its lawful orders.
So we always go back, that's what I was thinking. We always go back to the February 2021 order because it's the 2021 order that identifies default as the potential remedy for failing to participate in arbitration.
Yes, and that's the critically important order. But Judge, I think it goes back to I'm going to get the date wrong, I believe April 2020 order, back at the start of the case, first requiring the parties to arbitrate, because all of Mr. Michelson's conduct across 3 different arbitrations that he, as the judge found, undermined in bad faith was to avoid that first order.
All right, so let's assume that we were to agree with the defendant's argument here, and we were to say that once the judge ordered arbitration, the judge was disempowered to do anything other than wait for the arbitrator to act. What would be the remedy here?
It's hard for me to say. It sounds that if taking that argument on its face, the only thing that could be done would be to remand it to the Superior Court for a remand to an arbitrator that still hasn't gotten paid her half of the fee, and to just somehow order her to proceed with the substantive issues.
Maybe required Judge Josephson to decide the matter as it was presented to her at the time, which would be with only one side?
I think that would be a possible remedy, but I think the question then, Judge, is where does that take us? What
Yeah, what's the
substantive relief
point?
is that for Mr. Michelson?
Um,
And I see my time is up. If the panel has
Let me see,
questions.
let me see.
So how do you respond to his argument, though, that for civil contempt, he needed to be on notice and that the judge needed to apply a higher standard of proof?
First of all, I'll accept, just because I haven't read it today, my brother's representation in the fee motion that somehow comes up. Where the fee motion came into the picture was after the finding of default and sanctions from the judge. So the judge's decision here on appeal, finding the basis, was all predating any mention of contempt. Contempt didn't come up. Separately, Judge, I would say contempt is one procedure, inherent power to sanction is another. And they're not mutually exclusive of one another. They're different things that can be done in different cases. And this case was an extraordinary case, appropriate for an extraordinary sanction.
Let me see if Judge Hershfang has any questions. No, all right, thank you. We'll need.
Thank
to-
you very much, Your
we'll
Honors.
Need to leave it there and the case is submitted. The next case is 2022 P0411, Robert Sullivan versus LYNDSAY SCHMIDT. And I'll just remind those of you who are waiting in the courtroom that we will take a morning recess after this case. I'm going to remind the parties that the case is partially impounded, which usually means that we don't refer to people's names.
Morning. May it please the court. I'm MICHELSON. I represent Mr. Robert Sullivan, appellant.
Do you mind speaking up a bit?
I'd
And
be
you can move the microphone if that helps, but there's no substitute for projection.
Got it. Thank you. Your honors, this morning we're faced with 2 primary issues. First is whether or not the trial court's ruling on a motion in limine and those evidentiary consequences from that ruling was appropriate. The second is whether or not the trial court's analysis on the removal standards in this particular case was appropriate. I'll deal with the motion in limine first. In this case, the trial court issued a trial scheduling order requiring the parties to exchange witness lists 14 days prior to trial. Trial was scheduled for September 24th.
Attorney Sohn, I'm sorry to interrupt you so early in your argument, but I have read and reread these two trial scheduling orders many times. And I wanted to ask you about the earlier of the two of them. So you're referring now to the later of the two witness disclosure orders, which is, I agree with you, would require disclosure 14 days before trial. And I view that as a little bit of a red herring here, though I'm open to persuasion that I should view it otherwise. The first such order, though, which appears on Record Appendix 1, page 105, and I don't see it as a paragon of clear drafting, seems to require, I won't say clearly, requires a witness list to be filed and served at least 3 days prior to the pretrial conference, which was scheduled obviously much earlier than trial. I can't see from this order exactly when, but let's just agree that it was way before September, right? So the judge did rule on the basis of a purported failure to comply with the later ruling that the witness list was late, but why wasn't it late under this earlier ruling?
Sure, I'm happy to respond to that. As a matter of function, the earlier scheduling order was for a pretrial conference, and the clear/unclear order you refer to is commonplace. In fact, it's stock. It's what we receive as practitioners in the probate and family court as what are the required elements to your pretrial conference memorandum. Now, what happens at the pretrial conference is also common, though, although those pretrial scheduling notices are somewhat uniform across the probate and family court, what happens at the pretrial conference is not. Now, following the pretrial conference, a number of things can happen. There are judges in the probate and family court who, prior to scheduling a trial, require a secondary hearing, a status conference hearing, wherein both parties have to come and not only disclose those witnesses, whether or not they were listed on a pretrial conference memo, but also disclose the amount of time they anticipate for cross or direct of those witnesses. There are a number of judges who, at the pretrial conference, will set a trial scheduling order that is discussed within the conference itself, so that we know everyone's available. And in so doing, will limit those attorneys or pro se litigants to the parties or the witnesses listed within their pretrial conference memos.
But what I'm hearing is you're saying nobody said anything about him not listing witnesses in this pretrial disclosure.
That's right. Not only did no one
Okay.
say anything, but the judge did not make an order that Mr. Sullivan was limited to those witnesses listed or not listed in the pretrial conference memo, which would have been the most appropriate path forward if Mr. Sullivan was to be placed on notice that he would not be able to present witnesses at trial as a result of his failure to list them in his trial conference memo.
All right. And then as these orders are somewhat standard, even if they might be unclear, do practitioners understand that 14 days means 14 days before the minute that trial starts?
So typically, practitioners understand that there's a 4 p.m. deadline on the service of oppositions or motions. So for instance, if I want to schedule a motion and notice it for hearing, and I'm going to send it out by in-hand delivery, it has to be 7 days prior to the scheduled hearing. And if it's delivered in hand at 2:30 p.m. on the afternoon of the 7th day prior to the hearing, it's good service. It doesn't have to be at 8 a.m.
There's a statute that talks about the calculation of days.
As to this judge's order, no. As to the
general
provision of
statute.
notice, I wish there was. And I feel like my firm, we often discuss, isn't there this 4 p.m. Deadline notice?
I'm not talking about the 4 p.m. I'm talking about how days are counted.
How days are counted.
Is there
Well, let's
the
do it.
rules of?
No, again, my question was for,
Is there a
is there a
statute?
statute?
No,
I thought there was.
And there's no court rule?
There's no court rule relative to there's a court rule relative to the calculation of time if you do it by mail versus in-hand service, but as to the exchange of witness lists.
Civil procedure have a rule that talks about how you count days?
I believe you're referring to 6C or 5C, and I'm not sure that it provides for it to be the day before. So
For example, a rule that talks about whether you exclude holidays or.
I know exactly what you're talking about, and I think you're referring to Rule 5C. And no, I do not believe even under that rule, his notice would have been appropriate. And I want to be mindful of my time because I do want to get onto the removal question, but here on the motion and eliminate question, if you count September 10th, 11, 12, 13,
We know
14,
the math. Again, for us, oftentimes it's useful to focus on the legal questions we're asking.
I understand, Your Honor. And in this case,
And the ultimate question that Judge Henry asked you was, do you know of anything that calculates time from the time the trial was scheduled to start as opposed to the day the trial was supposed to start?
I do not. But what is important here is there is a long list of case law that, yes, provides for the trial judge to have discretion in issuing evidentiary orders, such as on those like a motion and eliminate. But the punishment should fit the crime. Here, Mr. Sullivan was precluded from presenting any third-party witness testimony relative to the issue of removal of his 4-year-old daughter 900 miles away.
But that's one of the issue really though was what were the benefits to the spouse and the child for being able to move. And I'm unclear that the witnesses that the father wanted to call would have really borne on that issue.
So that brings up the point that I understand Attorney Agnes will likely raise in her argument, and she did brief, which is how is this court to know what it is that those witnesses would have said?
Because there was no offer of proof.
Because there was no offer of proof. Now, of course, Mr. Sullivan was pro se, and were he not, the trial would have gone differently. But let's set that aside. Without a formal offer of proof, without a formal, Your Honor, I'd like to make an offer of proof despite your order because I know where this case is going to end up. Mr. Sullivan did present an affidavit of one of those witnesses outlining Ms. SCHMIDT's, let's call shortcomings as a parent and her behavior.
When was that affidavit submitted?
That was submitted with the pretrial conference memo.
Which witness was that?
That was Madison Shea. And it outlined her observations of this mother and her shortcomings. Now, that's important because the judge specifically made a finding that there was no credible testimony here of any shortcomings of this mother. Well, had Madison Shea been allowed to testify, she would have testified likely consistent with her affidavit, which outlined those shortcomings. In addition, it was undisputed that the parties lived with Mr. Sullivan's father and his grandparents, that Ms. SCHMIDT would spend her mornings with Lily, with the minor child, and Mr. Sullivan's grandparents. This went on for years, whereas Mr. Sullivan and Ms. SCHMIDT resided in Kentucky with the child for a period less than 6 months, and the child left when she was still an infant.
Well, yeah, but so one thing that's got me very puzzled, I'm hoping both parties can address, which is does the removal statute apply here where the child is not a native of Massachusetts and had not resided here for 5 years?
The removal statute applies because although she was not a native of Massachusetts, she had resided here for sufficient amount of time for Massachusetts to be her home state. And therefore, under the Uniform Jurisdiction Acts of Massachusetts, Massachusetts is this child's home state for child custody determinations.
What's your authority for that?
That is under the UIFSA statute, Your Honor, and I am happy to cite it after the fact. And of course,
Residence was something like 6 months,
6 months.
I think, under
Yep,
that
it's
statute.
It's a home state statute for 6 months, which is different from all the other 49 states in the country. And as I'm going to go on to my removal argument, makes an important issue here. Massachusetts, when removal is granted, Massachusetts loses jurisdiction of a child once that child resides for 6 months outside of Massachusetts. Again, that's different than every other state in the country, which would maintain exclusive and ongoing jurisdiction for child custody determinations.
What would be the consequences of that in this case? Because I've been puzzling a lot about, assume we were to agree with your first argument.
Mhm.
What would be the relief? That there would be another trial on the question of removal? And if so, I mean, at this point, obviously circumstances are different.
Circumstances are different.
And the calculus of what would be in the child's best interest at this point, I could envision would be different.
And that's not so uncommon in these cases, right?
Right,
We have
and
Pranavu
so-
1, 2, and 3 that took place over a period of 6 years. The children went back and forth from New Hampshire. This is not so uncommon. Here, Massachusetts does not lose home state determination because the notice of appeal
Well,
was
but at
filed
this
timely.
point, what's the home state has
It's still
changed.
Massachusetts. No,
Why?
because a notice of appeal was filed timely and this action is ongoing to the extent that
But
this
the
court.
statute, I think, says that it's based on residence. And at this point, 6 months of residence have occurred in Kentucky.
It's based on residence, except to the extent that there are ongoing matters. So to the extent that when this case was filed, both parties were residents and the child was a resident of Massachusetts. Until this case, this particular case that was filed when they were all residents of Massachusetts comes to a final conclusion, then Massachusetts remains its home state, which is to say that if your honors,
So what section of the uniform statute is that?
I can't cite to it right now, Your Honor, and I would be happy to submit a supplement following the hearing, but I cannot cite to it right now. I do know, however, that to the extent that this case remains open, so that this is an appeal of a case that was filed when everyone lived here, including the minor child. Until this case reaches a final resolution, Massachusetts remains its home state. I'd like to touch base on the removal issue itself, because this is an important one. And I actually should answer your question first, because you asked me, what's the relief here? What will happen? And going beyond the jurisdictional issue, to the extent that this court determines and agrees with me that the judge's ruling on the motion in limine was improper, then further findings would have to be made, or further evidence would have to be taken and further findings made relative to those third-party witnesses after they testify, which is candidly based upon the litany of case law about what can be done in order to avoid prejudice to the moving party on any evidentiary issues should have been done. Because there was a second day of trial. These witnesses could have testified later, giving mother an opportunity to depose or prepare for cross-examinations. Moving on to the removal issue, Your Honors. Here, there are two standards by which removal can be based. The Janus Frontispidu standard, which is not just a best interest standard. It's whether or not the movant has a good and sincere reason to go, and whether or not it's in the child's best interest, considering the custodial parent's interest. And for the Janus standard to apply, there has to be a 2/3, 1/3. One parent has to be a primary parent. And then in the Mason v. Coleman standard, it's simply a best interest analysis. Mason v. Coleman is applied when there's an equal joint parenting arrangement. In this case, the court made a finding that it's undisputed that mother was the primary custodial parent, but that's actually not true. Mother was not the primary custodial parent until there was a ruling on a motion for temporary orders. When Judge Cronin, the trial judge who was managing this list prior to Judge Moses taking over, made an order on temporary orders. There was no.
How relative to the data decision, how much earlier had the temporary order been entered?
It was just shy of a year. However, setting that aside, that's still a smaller percentage of this child's life. Setting that aside, should not have the judge have at least considered the Mason v. Coleman standard, which is the child's best interest. What's important is even under the Janus standard, the court is required to consider the child's best interest, and the court did not.
Okay, we're going to leave it there unless there are other questions. All right.
Thank you so
very
much.
much.
May it please the court. My name is Eileen Agnes and I represent the appellee in this matter, Lindsay SCHMIDT. And I just want to briefly spend 1 minute on the facts. My client was 29 at the time of this trial. She had epilepsy, had had it for a number of years, was having active seizures that were accelerating as a result of the stress of the litigation in this case. In addition to that, both the motion judge and the trial judge found that she was the primary caretaker of this child and had been since birth.
I'd like to look at your motion in limine, which I'm looking at. I think it's, I don't remember which volume of volume 2, page 21. And as I read that motion, the basis for the motion is that the witnesses were not disclosed, quote, at least 14 days prior to trial, and that said witnesses were disclosed at 3:29 p.m. on September 10th.
Judge Wolohojian, just so you understand, at the pretrial conference, Mr. Sullivan disclosed 4 witnesses, if you can call them witnesses, because he listed it as affidavits, one of which was Madison Shea, one of which was Daniel Garcia, and 2 other people. None of those people were listed as trial witnesses when he filed his list of witnesses, which I do not believe complied with the court's order.
Okay, but I'm just trying to get to a different point,
Yes.
which is your motion appears to be, and your argument to the judge when you argued this motion appeared to be that the witnesses were not disclosed 14 days prior to trial.
Well, the language in the order, the post pretrial order of June 3rd was at least, it was not 14 days before trial. It's at least. It was very specific, which is unusual.
So if they were disclosed 14 days prior to trial, that would seem to satisfy it.
I would argue that the judge took the position that it was not in compliance with the order because she took the position that it was 9:30. We started this case at 9:40 a.m. that morning. In addition to that, Judge, my motion in limine.
Your motion based on the time of the day. In other words, if he had sent over the witness list at 9:15 on the day he did, that would have complied with the order?
I do not believe it would have, because I think it should be the day before that would have been in compliance. But I would indicate that.
All right, so let's assume that so your argument to the is your argument that it was too late on the right day, or that it was 1 day late? Because that's not clear from what you argued to the judge, and I'm not sure the judge understood.
I believe that she understood it, and I argued that it was not filed timely.
Right, that's all you said. So I'm trying to figure out, because to me, it seems like it was on the right day. So your argument would seem to turn entirely on whether it required that to the minute it be done before the time of the trial. And if that's your argument, then I'm going to ask you for legal authority for that.
The only thing that I cannot cite a case to you for the legal authority, but I can say that timely in the probate and family court, for example, if you have a motion, the opposition is due the day before, it would not be considered timely if you filed it at 4 p.m.
I know, but we don't have something that says timely here. We have an order that says at least 14 days ahead of time.
And the court should also be aware that Madison Shea was not on my motion in limine.
I saw that.
And that was because he had to some degree disclosed her in his initial pretrial conference, even though it said affidavit of Madison Shea.
Let's assume you're correct, and the witnesses should have been disclosed the day before. I didn't see any showing of prejudice in those 24 hours. In in the idea that they weren't disclosed in the 24 hours?
Well, I can say the following: discovery pursuant to the pretrial conference order was to end on July 1st. If they had been disclosed, I potentially would have sent a notice of deposition to them and had an opportunity to discuss what they were going to say.
But the difference in time is only 1 day.
Except that if you go back to the pretrial order, which I think is important, even though the court didn't enter an order if they aren't disclosed, et cetera, I think the fact that discovery closed on July 1st would have prohibited me from knowing what they were going to say, with the exception of Madison Shea, they had attached an affidavit. And I would simply say that once you get to that point, and I understand the court's position, but my position is that my client was severely prejudiced by getting these at 3:30 or 3:40, 14 days before. I did not have an opportunity to even discover what they were going to say at that point. I think the court does have to look at, though, the lack of an objection and an offer of proof, which I think is particularly significant in this case, because if you take a look at the list of witnesses that he has offered, the court bent over backwards to allow him to put in exhibits which were not in compliance with the law. For example, one of his witnesses was a work colleague.
I'm looking at the argument you made, because we don't take new arguments here. On page, see, it's Record Appendix 9, Volume 3. This is the transcript of the hearing on the motion in limine. The judge says, yes, the motion is based, I have to hold you to the same standard as an attorney. And yes, because they weren't provided, the judge says 14 days, at least 14 days prior to, from what I understand. Counsel, she directs a question to you. When did you receive the list? You say, Judge, a day after the order. So technically they were not within the 14-day time. And then he responds and says it was what, Friday? So I think Friday at 9:30 in the morning would have been your 14 days. So I take it that at least as presented to the judge down below, your position was that her order, the judge's order, required that it be disclosed no later than 15 days before, because it used the word at least 14 days.
Judge, my position was that it wasn't timely filed, and then the court weighed in after that, looking at the time frame, and I believe understood the time frame and said the trial started, because otherwise she would not have made that comment if she had felt that it was due, that it was timely made. And she then goes on to say that the witness list would have been due at 9:30.
I didn't see the judge saying that. Where does the judge say that?
I believe that she made a statement after that.
Well,
In the transcript.
I'm looking at it. You might want to pull it up.
I do not have the transcript with me.
All the judge says, sir, the order is clear. The order exists for a reason. Counsel has to be on notice, so the witnesses are excluded. He says, all right, court, all right, sir, you are technically the plaintiff because you're the first filed complaint, so you can proceed. That's what the judge says.
And then you will see that there was a comment, because after that, Mr. Sullivan then stated, I had to work that day, so I couldn't get it.
That was before then.
Yes, I couldn't
The
get it.
judge never, I think, offered an interpretation that the deadline was calculated from the time the trial was scheduled to begin, as opposed to the date.
I understood.
Are you taking the position in this appeal
Mhm.
that the time is relevant as opposed to the date?
I think I take the position in the alternative, but I take it that he did not get it timely because he did not get it there at the time that the trial would have started, which then would have been 14 days before. And in the alternative, my argument is that when she says at least 14 days, we go back.
Okay, because that looks to me like the argument that you made below, the
Mhm.
second one, that you didn't make the
Mhm.
argument about 9:30 in the morning down below. Unless you can point to me, because you don't say it in your brief. I mean, in your motion,
Mhm.
and I didn't hear you focusing on that. I didn't see anything in the argument on the motion.
Mhm.
So I take it now, the argument is it should have been disclosed the day before.
If you look at my brief, I believe I argued that in the alternative, that the day before
Okay.
would have been the appropriate
So
day.
let's assume that we find that it was timely.
Mhm.
What then? What is the relief here?
I think that then you have to go to and look at, did he object to this ruling? And was there an offer of proof? Because I think if he had made an offer of proof, then we would be in a different position, I believe. If you look at his witnesses, as opposed to the witnesses that he had included in his pretrial conference, if again, it doesn't say witnesses, it says affidavits. And then he lists 4 people, one of which was Madison Shea. The other, all of the witnesses that you're looking at are relatives, because he had to disclose who they were, sister, mother. None of those people had had contact with my client she had moved out of the paternal grandfather's residence in late August, early September of 2020, and the trial was in 2021. So we had indicated during the trial, and there was evidence there that the paternal grandmother had in fact taken my client with the child to various appointments, which is what I believe, based upon affidavit that she had filed previously in the case, that was what she would be testifying to. That was not really a contested issue. As I stated in my brief, for example, the employment records, he was going to have an employee testify. The employment record showed the time that he worked, and it was basically date and time when he did some overtime. And he himself testified to when he went to work, what time he left. And the other people were literally siblings of Mr. Sullivan. And I have no knowledge specifically when they testified, but they didn't have a lot of contact with my client. She had been living in her own apartment for over a year at that point. And so I think if you look at it, and he didn't make an offer of proof, he didn't object. So if there was something more specific, I will say that a lot of his evidence came in based upon the judge's very liberal rulings on evidence, including hearsay texts between Madison Shea and a friend, and various other information that he had put in. It all came into evidence and it went in. For example, he wanted to make an allegation that she had an issue with alcohol, and that she went to this Victory Bar and Grill, which was a restaurant. The judge had before her, including all of her bank records and all of the information that was summarized within those bank records were there for the judge to see. And the judge made no finding
I think the bank records showed when she went to the restaurant.
They did. The particular charges and it didn't specifically say what she purchased, but then Mr. Sullivan testified to that, what was going on. And again, there was all kinds of evidence about Mr. Sullivan's alcohol issue.
So you're saying even if the judge improperly excluded all of his witnesses, we should still affirm because other evidence came in that eliminated the prejudice to him. Is that right?
Yes. And if I can briefly just touch on the Yanis versus Mason versus Coleman. Under the Hegarty case, specifically a pretrial order awarding my client primary custody would have been sufficient. And the judge made very, very specific findings, and I will leave it to her rationale and findings as to my client being the primary caretaker. Clearly, it was in her best interest. This was a woman who had epilepsy, who could not work, who financially, her mother was draining a 401k to pay for her apartment and other living expenses. And it was an imperative that she be able to leave and have the support of her mother where she could live in that home, have a room for her daughter, have somebody to transport her and the child to school, to medical appointments. And And again, I think that the evidence was clearly and supported by the judge's substantial findings.
So you're not relying on the actual order that was entered, making her primary parent. You're saying that as a practical matter, she was the primary parent and that the judge found that she was the primary
Yes,
parent.
both the motion judge and the trial judge found that specifically.
And just
And-
in terms of timing, I want to make sure that I have the chronology right. Attorney Stone mentioned that that temporary order had been in place for about a year before the final determination was made. In the period before that, I understand the parties had agreed on working joint parenting situation following the time they split up, and before that temporary order was entered. That was, if I remember correctly, a period of some months. I apologize. That was a terrible question. Let me start again. It was a few months that they shared parenting under an agreed order after they split up. Is that right?
Yeah, yes, but while they shared parenting, my client had the child every Friday, all day, because he was working. My client took the child to every single medical appointment after the 5-month period of time. She was solely responsible for all of the things that a primary care parent would be responsible for. He had the child and dropped the child with his mother, using her as a babysitter for some of the time. But essentially, I think, and I've laid out in my brief, the issues that provided and established her as the primary caretaker.
Let me see if there are any other questions. No. All right. Thank you. Thank you
Thank you
both
very
for
much.
your argument and for your briefs, and that case is submitted. The panel's going to take a 10 to 15-minute recess, and then we'll come back for the final 3 cases on the list.
What's in recess?
Thank you, John.
Ready, roll that.
That's all.
Yeah.
Oh, cool. Thank you.
Oh, I think, is that all of them?
Yeah.
Yeah.
Yeah. Thank you. Fantastic. I'm gonna suggest you make a move soon because. Oh, no, good point. It's gonna take the whole Thanks. I wouldn't have been able to, you wouldn't have been able to bring it in here in fact. All right. The toasted it, made it smell real good. The whole works. Thank you, Tom.
I would like to stay away from that.
Oh, man. I'm sorry.
Yeah. It's better. I will. Thanks.
I'm taking 15 minutes and Attorney Cabanner is taking 5.
Okay. For the rectory.
Correct.
Got it. Okay, great.
I'm just here for the.
Just for the show.
For
For fun.
the show.
Yeah.
We're the same now, as you know.
Or maybe I should stand over here.
Please don't.
I have to say, with the first time. I had. Yeah, I remember. I was here. And so he had put together the record. And you know, my supervisor said, they're responsible for the record. Somebody, petitioner says. Got up there. And they were on private book there. And blaming. Marshall's like. So she would dive in. And then, yeah. I was just so just like. Excited. And then, yeah, Chief Justice leaned forward. And this is. Yeah, I know it's crawl out.
Get started.
Horrible. So, yeah, there's my, yeah. Yeah, I always do that the night before. Yeah, this is how I started.
That's good.
Yeah. In case I forget my name and want to say at the start.
Double spread.
Yeah, just put it out and just, you know, kind of remember where things are and like little shorthand.
Yes.
So hopefully, please God. just don't want me- want me wrong.
It's like.
Well, but that's great. That's good. Oh, so that's perfect. Yeah. Knock and run away. That's good. I'm glad you're better. Yeah, it's scary when you're sick that long. It does.
But it was.
But yeah, you were. Yeah. Oh. Ah. Sure, yeah. Yeah.
That's signed.
Oh, like milk duds, right? Milk duds are junior ones. Junior ones. Might be something from the 70. Right? Yeah, we should, because Armstrong. Portraits.
Oh.
I recognize that. Do you know who? Yeah, do you know who that is?
I didn't know it.
I don't either. None of us do. We were saying they really should put their name at the bottom, right? So that, you know.
JC, someone told me to look at.
Oh, yeah.
Yeah. He's coming up with like issue. Yeah, actually Monday and that's JC. Recording works and then all of a sudden it's not working. So I was
Really?
checking this week and I hope it works because yeah, I want to watch it and gauge where they're in.
Are you doing the body cam?
Yeah.
They asked me all, Justice Kafka asked me all about body cam.
Well, so
Which I
was
knew.
supposed to move hard. It's supposed to be that week. So then they
Yes.
were ready to go.
Yes.
Yeah.
And I just happened to find it and I'm like, I'm glad I found this because I bet somebody's going to ask me about it.
Yeah.
And I didn't realize that you didn't argue it. I thought you
Yeah,
had, and I
we
was
were
like, it's
supposed
going to be,
on. Yeah.
because I thought it's going to be on their minds. So I
Yes.
better be ready for
Yeah.
questions. And Justice Kafka just kept at it.
Hopefully you
Like,
guys answered everything.
no, I think no, it was just sort of, I mean, my case is so different from yours.
Right.
So,
it's a interrogation.
yeah, it's a very different.
Court all rise.
I think it's still morning. We've lost our clock. All right, we're going to call the cases first. This is 3 separate appeals that we're hearing in a single argument. They've been paired for argument. And the cases are 2020 P0747, Commonwealth versus Markees Mitchell. 2020 P0767, Commonwealth versus Terrance PABON. 2020 P0808, Commonwealth versus Pedro ORTIZ. Now, I understand that there will be Attorney Neves arguing all 3 cases for the defendants with respect to the arguments that they have raised in common.
That is correct.
And then Attorney Klabner is going to be raising the only argument you raised separately, which has to do with peremptory challenges, correct? All right. And that in combination, the defendants will have 20 minutes to argue. Have you agreed on an allocation of time?
Yes, Your Honor. I'll be taking 15 minutes and Attorney Klabner will take 5.
Great. And then Attorney Hartley, you're going to be arguing for the Commonwealth. You'll have a total of 20 minutes to argue all 3 cases. Okay, so we're all on the same page. And at least at this point, and that's a good start. So we're ready whenever you want to start, Attorney Neves.
Thank you. Again, Catherine Neves, I'm counsel for the defendant appellant Markees Mitchell. And I am leading with the issue of the juror bias. And a reasonable judge, armed with the following facts, would conclude that the juror in this case would have been subject to a valid for-cause challenge.
All right, so I have so many questions and I am sorry to cut you off.
Oh, that's fine.
So soon. Let's assume this is a hypothetical. Let's assume that the juror, that everything that happened in the post-trial proceedings, in other words, let's just say the juror had answered the questionnaire differently, and that the judge during voir dire had asked all the questions that the judge asked during the Fiddler hearing. The juror answered exactly the same way. And at the conclusion of that, one or more of the defendants had challenged the juror for cause. Is that clear enough? So in other words,
Absolutely.
Let's assume that all of this had happened sort of in the way we wished it had happened.
Correct.
Okay, and then someone challenged a juror for cause, and the judge denied that. What would be our standard of review of that decision?
I think it would be a very difficult standard of review because I think a judge has a lot of discretion to measure juror impartiality. That said,
Right, if the judge had found, had credited, because we know here, so let's also assume, let's add into my hypothetical, the judge had made the same credibility determinations and findings that she did at the end of the Fiddler hearing and said, I've eyeballed this juror. I believe her when she says that she is indifferent. I'm going to find that the juror is indifferent. What would be our standard of review?
well, I guess, I mean, that's a little more complicated because I think it's hard to put the genie back in the bottle so that what.
I understand all that. I'm just trying to find something. I assume that we review that for abuse of discretion.
Well,
I think I'm wrong on that.
I think that when you look at, I don't know, because
I think they have broad discretion. I think if the judge finds, I think
yes.
we have a lot of cases that say the judge has the benefit of eyeballing the witnesses,
Right.
or a juror, and looking and saying, you know, I believed him. There are so many situations where a juror discloses something and the judge, and I've read almost the entire voir dire here too. And of all the witnesses, the judge looks at them and says, well, do you think that would interfere with your ability to decide the case impartially? And the juror goes, no, I don't. I think I'd be fine. That's
Right.
usually the end of the story. So what I'm struggling with is when the information comes out afterwards, why is the standard of review different?
I would guess that the standard of review is different because the juror failed to disclose, positive non-disclosure, didn't give the court and the parties an opportunity to assess whether a for cause or a peremptory challenge could be used. So I think then the standard is just different.
Would still come down to, wouldn't it, whether the juror was indifferent?
Well, I don't think the problem is it's impossible to measure that now. The question that the judge asked the juror here at the April 2018 hearing was, were you biased, or, you know, were you biased doing, you know, that's a different question from, do you think you can be indifferent? And it's in a different posture. The question of whether the judge, and I would say to the court that the juror who failed to disclose his juvenile record in this case, when you look at, you know, the Commonwealth checked his record, found he had a record. He didn't disclose it. They brought him in. He said, I thought it was sealed. I didn't realize, you know, the same kind of thing. And I made a mistake, and I've changed a lot. And the prosecutor said, look, you know, this was something that was very plain. You know, he should have disclosed it. It's very clear. It brings up a question of whether he can be fair and impartial. Even if he says he can be fair and impartial, it goes to his ability to perhaps follow instruction and perhaps to decide issues based on the evidence. And Judge Fabricant said, you're absolutely right. It is a problem. He did not disclose. He knew the instructions were very clear. I made it very clear. I'm going to excuse him for cause.
Right.
This juror has.
But can I want to, and I'm sorry to cut you off again.
That's okay.
Because it seems to me that the standard of review is going to determine everything here. I mean, that's actually true in most appeals.
Yes.
So I'm going to read you the holding in McDonough Power Equipment.
Mhm.
Okay. We hold that to obtain a new trial in such a situation, which is a situation like we have here, motion for new trial, a party must first demonstrate that a juror failed to answer honestly a material question on voir dire, and then further show that a correct response would have provided a valid basis for a challenge for cause.
Yes.
The motives for concealing information may vary, but only those reasons that affect a juror's impartiality can truly be said to affect the fairness of a trial. So if I look at that last sentence, if the trial judge has found that the juror's motivation for not disclosing information that should have been disclosed in the juror questionnaire was innocent. In other words, not designed to try to deceive, but was a mistaken belief that it was irrelevant, which is what the judge found.
Well, I would respectfully disagree with that.
You don't think that's what the judge found?
No, I mean, I would direct the court to what she said, and it's at my addendum at 55. As to Carl, the answer was, I mean, she said it wasn't intended to deceive, but look at the words. The answer was inaccurate, and the juror knew it was inaccurate, in that the juror knew Carl had been convicted of crimes and was incarcerated. And she said she was she performed her own independent evaluation of relevance. That independent evaluation violated the court's instruction to disclose all responsive information regardless of the juror's view of relevance. The judge did not find that this was an honest mistake.
Well, look, I mean, I
because
think
it
we have to,
wasn't.
again, we have to read the whole thing. The judge found the inaccuracy was not dishonest, however, in that it did not arise from any motive to mislead or concealed, but was based on the juror's independent evaluation of relevance. The independent evaluation violated the court's instruction to disclose all responsive information regardless of the juror's view of relevance. And that
Right.
was an explicit instruction that the judge made during the voir dire process. So
Yes.
that is a finding of, I'll call it misguided, but innocent motivation.
I would say that, and that leads me back to the standard of review, right? So findings of pure fact are going to be upheld by this court unless they're clearly erroneous.
Mm.
But I would direct the court to Commonwealth v. Emerald in a case where it was a post-verdict inquiry about a juror who did not fill out a questionnaire accurately, but it was a good faith mistake because she had forgotten the underlying incident that led to the falsity of her answer. And I would direct the court to what the Supreme Judicial Court said there. The reviewing court still has the ability to grant relief if it is left with a firm conviction that a mistake has been made, and that's as to findings of fact. As to
So if we accept these findings of fact, let's say that we accept what I just read as being not clearly erroneous. What happens to your argument?
I think the court needs to look at the findings of fact as a whole, and the court will do its own analysis of application of those facts to the law. And the law here, the court set forth the two-prong test.
So would we have to find, in order for you to succeed on your argument, would we need to find that the juror was actually motivated
No,
in a bad way?
no, you would not.
Okay,
Yeah,
because
bias
that's what it seems to me the Supreme Court is saying.
I don't think they are. And I would,
Well,
yes, I think, but
I mean, I know
bias
you're
can-
relying on Sampson, but there's been a subsequent case out of the First Circuit that seems to cabin Sampson.
I think that what Sampson does say, and I think is true, and I think it's certainly true with respect to the for-cause challenge for the juror who failed to disclose, is that you don't have to have a malevolent, malicious bias to be removed for cause. And the standard here is whether there was an answer that was not accurate in voir dire, and whether that answer, had it been given at the voir dire, would it have resulted in a for-cause challenge?
Not
And this,
just a for-cause. I think it's indisputable that someone would have challenged the witness for cause. But
sure,
that can't be the test.
but that is the test.
It is not the test according to McDonough.
But
It is the language that Sampson has used. And Sampson, there's been a subsequent case, Farias versus something in the First Circuit, that goes back to the McDonough test and says that just reading the binary test in isolation is incorrect. So I think that even to the extent that we wanted to rely on First Circuit law as opposed to our own law, the First Circuit, Sampson is not the latest and greatest word on the topic.
okay,
So And in our Emerald also adopts McDonough. And McDonough makes clear that the ultimate question is whether there's a binary test,
Yes.
but the ultimate question is whether there was a motivation to conceal the information that only reasons that affect a juror's impartiality can truly be said to affect the fairness of a trial.
Well,
So if we have to accept the judge's finding on motive, right? This is where I get hung up.
I understand. And I think that I would direct the court again to Emerald, that if the court believes that a mistake has been made as to that, and a clearly erroneous standard is not, beyond this court's review, I would ask the court to look at this juror's testimony, and as you have, and look at it carefully and look at the facts that got
Okay.
disclosed right here.
So,
Because
and
this isn't-
don't worry about the clock. So then what I hear you telling me now is that, yes, we would need to find that the juror's motivation was designed to conceal bias. And what is that correct? That's what we would need to find?
I
Is
am
that your
going with the
argument?
court on that based on
Okay.
what, this
Okay,
is what,
if
so I am,
if that's what we
Yeah.
need to find, what was the evidence that you would have the burden to show, I think, by a preponderance of the evidence,
preponderance, yes.
that her motivation when she didn't disclose, I mean, can we agree that the information about the half sisters really
Yeah,
neither here nor
we haven't-
there, neither
that's-
here nor there? I
think the judge's findings
information-
are-
yeah, I think the information about her, I don't even know how to characterize the relationship, but the father of her child, that's probably neither here nor there. It all boils down to the information about her half brother. Is that correct?
I think that's correct.
Okay, so can you now tell me what evidence you think would compel our conclusion that the juror's motivation to not disclose her half-brother's situation, and we have to look at it back in 2010, right? Was to disguise bias. So what was the evidence?
The evidence was that at the time of trial, her brother, Carl Baxter, was incarcerated for serious felony convictions, assault with intent to murder and gun charges.
But she didn't know
She knew
the
that.
charges.
She did know that. That was in the Boston Herald article.
She knew what was in the Boston Herald
Yes,
article.
she did. And she admitted that she did. She knew about that when the article came out in 2007. And that article describes her brother as the leader of the Lucerne Street gang. So in 2010, she was well aware that he was serving sentences on those charges. And that article describes the charges as assault with intent to murder and several gun charges. So she knew that then. Despite her testimony at the April 2018 hearing that her relationship with her brother was on and off, she acknowledged that she introduced her brother to her daughter's father, and his affidavit explains that he met Carl Baxter at the hospital in 2002 when their daughter was born, because Carl was at the hospital where his sister was giving birth to her daughter. So there's a relationship there. She was well aware of it. She had discussed with Carl's mother, they share fathers. He has a different mother, and with her sister Chantel, the charges, what it was about. Later on in the hearing, then she said that she didn't know about the Lucerne Street dogs, but she said, I knew what it was.
About this case at the time she filled out the questionnaire.
I don't know.
Nothing.
But the
Okay.
point,
So that would obviate some kind of inference of motivation at that time. but to my mind at least.
Well,
And then what does she know when she's questioned by the judge about this case?
well, she deliberated.
No, at the time she's answering the questions.
Oh, the voir dire
because we're trying
questions.
to get to the question of what was her motivation in not disclosing the information.
Well, I
So
think,
if it had been a contract case, for example, and she didn't disclose this information, would you be arguing that she had a motivation to conceal bias?
well, I think I just have to take the court back. And I know Sam said there's a subsequent case, but I do have to take the court back to that case in talking about how difficult it is to get at bias. And that it may not be, jurors don't want to admit they have a bias. They might not know they have a bias, but they have a bias nonetheless. And that's why honest answers during voir dire are crucial, because if you don't answer honestly, then the court can't get to the bottom of whether you might not be the right person for this case. And certainly if she had answered honestly, my brother, Carl Back, I have a brother who is in prison for case, convictions tried out of Suffolk County. I know we've all read enough transcripts to know that somebody who has a sibling or a family member who is serving time for a case out of the same county, the red flags go up immediately. Not that they have some hidden secret motivation to convict these people, but because it may be too close, right, for them to be impartial. And Samson talks about that.
But I think it's important to focus on the question that Justice Wolohojian asked most recently, right, which is not, would counsel have followed up? Might the outcome have been different? All of those things I think we can agree are true. But what, at the time that this juror was sitting in the chair being questioned at voir dire, what have you proved what evidence have you put forward that show that her motive in not answering completely was to conceal bias? And if you compare it to the reaction of the juror in the Sampson case, these are two extraordinarily different situations. That was a juror who's, as found by the trial judge, whose physical demeanor and responses required some sort of conclusion. This is a juror whose physical demeanor and responses compelled the trial judge to reach a very different conclusion. So I don't think citing Sampson, whatever its status may be as the latest and greatest, is all that helpful in a case where the judge who had the opportunity to assess the witness's demeanor and credibility found that she was credible. And my memory is that the testimony of the juror, and tell me if this is contradicted in any way, was that at the time she sat in that chair and then sat in the box for the trial, she was not aware of any relationship between the gang in which her brother was a member and the gang or a subset of a gang of which the victim was a member. Do I have that right?
Yes, you do. And I only send you back to Sampson for the general discussion of how you measure this. And the reason why it's hard to find bias is why you go back to the two-pronged test, which is armed with the information that would have been generated had the juror been honest at the time. Would there been a valid basis for a for-cause challenge, leaving aside whether one side or the other would have exercised a peremptory challenge? And I think the only way you can do that is to look at what would a yes answer, yes, my brother is convicted, what would have happened? That's the only way you can actually measure that.
I'm gonna ask that the defendant submit like a 5-page supplemental memorandum on the following case. Faria versus Harleysville Worcester Insurance Company, 852 F 3rd 87. It's a 2017 case out of the First Circuit. And because there, the First Circuit unambiguously says the two steps that that Sampson looks at. I have to say the way Sampson is written does not make much sense to me, because it can't be that the test is, would there simply have been a valid challenge for cause? And that's why my very first question was, what would we be reviewing if all of this had come out at the time? We're really only looking at, I think, whether the judge was required to have dismissed the juror for cause. And so in Faria, and I realize you're not prepared to talk about this case because you didn't brief it, although it's a 2017 case. So it, in my view, both sides, it wasn't also briefed by the Commonwealth, both sides should have found it given the reliance on Sampson. But it says, in such a scenario, we have required litigants to demonstrate actual prejudice or bias. And we have said that the burden of proof on this point must be sustained, not as a matter of speculation, but as a demonstrable reality.
So, Your Honor, this is a civil case.
It is.
I think that makes a huge difference, Your Honor, because the defendants have a Sixth Amendment right to an impartial jury.
Right.
And
So you'd still have to go back and prove that the juror was not impartial.
But again, if the juror had been honest, she wouldn't be on that jury, right? So, and if she had been honest, she would have been removed for cause, just like the fellow who didn't disclose his.
That's a fair point. Okay, but even if we assume that, we're not in the posture of that. We're in the posture of a new trial where you have to motion for new trial, where what is it that you have to establish?
I think that if you put a defendant in the position of trying to get behind and try to prove what a juror is thinking before they can be found biased is an unscalable hurdle. I mean, there's no way a juror would ever admit to anybody that I wanted to be on this jury because I wanted to convict these guys because my brother was friends with the victim. I mean, nobody's going to say that.
No, but there would need to be some proof. Do you think it's unreasonable to require some showing that there was some indication in the trial, or some indication in the trial, that the juror was not indifferent?
I think, and certainly what I believe the Supreme Judicial Court's case in Cousin says is that when a juror is dishonest in answering a voir dire question, and whether you want to call this a lie or you want to call it inaccurate, it was a positive non-disclosure. That fact in and of itself is an indication that that juror can't be trusted to be fair and impartial.
Could be, but if the judge finds it wasn't in this case,
But
what
it's-
then? It could be,
But it
I
wasn't
don't
found in this case.
understand, I don't know, I thought it wasn't relevant. If the judge finds that the motivation was innocent, incorrect, but innocent,
Inaccurate, but not designed to
not
deceive.
deceitful.
Inaccurate and using an independent assessment of relevance, which
Right,
I would
so
say
if
every
that's-
lie is an independent assessment of relevance. I mean, it's a word salad, honestly. She doesn't say it was a good faith, honest mistake. And, a judge is supposed to find the way to justice here. This judge removed for cause people for far less compelling reasons than what was found here. And instead, this juror made a mockery of the process, given the relationships that she had. And the trial judge perpetuated it by making findings like this.
Okay, so when the judge finds that an accurate disclosure by the juror would not have given rise to a viable challenge for cause, I think you're saying that that's a mixed question of law, fact and law.
I do,
Okay.
absolutely.
And if we conclude that Amaral controls, do you lose?
I don't believe so. I think the facts in Emerald were very, very different, the opposite of what we have here. A juror who answered.
Right, she
honest-
didn't remember.
She didn't remember.
Right.
She answered the question honestly and in good faith with the knowledge that she had. It was an assault that happened to her when she was very young. She had no recollection.
Well, so one of the facts that troubles me in this case, when I don't know that it's a fact, that's what I'm asking, is there's some evidence and there's some indication in the briefing, because I have it in my mind, that the brother taunted one of the defendants.
That's
And-
how this happened. This is how we found out.
Right. And so is there any indication as to how he found out his sister was on this juror? Because I can't come up with an innocent explanation.
I
Can't wait to hear what the Commonwealth has to say about that.
I can't come up with one either, Your Honor. But it was shortly after trial. They were both being held at Sousa Baranowski. He went up to him, called him a derogatory name and said, "That's why my sister convicted you." And that's what generated the first Fiddler hearing or motion. Counsel attempted to make the connection. The judge said not enough. Came back in 2017 because there were social media postings showing a close relationship, sibling
Okay, so
relationship.
there's also a reference in one of the defendant's briefs that there was trial testimony about the Lucerne dogs or MOB, but there's no citation when it says that. And this is about an eight-week trial. So where is that? Because I seems like you could point us rather than us
I
taking
will
a.
find it. I know that it was not referenced during jury selection, but it was referenced throughout the trial. And I have notes on that at home, but I
Okay,
didn't bring
all right.
them. But I can certainly send a letter. I can access that very quickly.
but you're-
People were cross-examined about MOB.
Okay, all right.
It was raised in final arguments, closing arguments. So MOB was talked about a lot during the trial.
And your client is not raising the peremptory challenge argument, correct?
That is correct, Your Honor.
Okay.
There was uncontradicted testimony by the juror that she had no contact in any form with her half-brother while he was incarcerated. And the judge was entitled to credit that.
Yep.
Yep.
Yeah,
So
she's a demonstrated
I think
liar.
going to Judge Henry's question is, what evidence did you put forward that however the half-brother learned that the juror had been on the witness, that it came from her? None. Okay. I'm going to see if there are any other questions. Thank
Thank you.
you.
Thank you, Your Honor. Richard Klebanner for defendant Pedro Ortiz. Before I get to the issue which I meant to discuss, I just make 2 points, if I may. Your Honor has raised the question of McDonough several times, and I would note that in interpreting McDonough, the Supreme Judicial Court in Amherst said McDonough makes clear the crucial inquiry is whether the defendant's answer was honest, that is, whether the juror was aware that the answer was false. That's a somewhat different question from an intent to deceive, and I think that's the real question here. And I think there's no question, but that she was clear that she knew her answer was false at the time.
But then the judge went on to, then Emerald, they go on to talk about that and explain that statement as to that the judge believed the juror's testimony that the juror had forgotten about the incident, and therefore the non-disclosure was a quote honest mistake.
Right.
And then also, and this I think is, this is tricky for the defendants. I mean, Emerald seems to suggest that there needs to be a showing of actual prejudice.
I think that's for a challenge for cause. I think that's correct, Your Honor.
Right, that it has to be, the juror was actually prejudiced against him.
I've
Yeah.
not.
All right,
That
so
may
do
be
you want
correct,
to
Your
go
Honor.
to the question of, I don't want you to run out of time.
Yeah,
Do
yes,
you want to go
thank
to
you.
the question of peremptory challenge?
Thank you, Your Honor. So the issue here is what's the proper remedy when the dishonest answer, and I use dishonest in the sense of not correct, knowingly not correct, has deprived the defendant of the chance to intelligently use a peremptory challenge.
What's our standard of review?
This court has held that this court and the Supreme Judicial Court have held that the improper denial of a peremptory challenge is structural error.
No, that's not correct.
I would cite Commonwealth versus Gonzalez, Your Honor.
If it's a preserved, if it's preserved, it's structural error. It's not
Yeah.
preserved here, obviously, because you didn't have the information upon which to exercise the peremptory. I think the weird thing is that our peremptory challenge cases all seem to involve a situation where the judge incorrectly didn't allow you to exercise a peremptory, either because people miscalculated the number of peremptories or some other reason. That's not this case.
On the first question, whether it was preserved, you're right. It could not be preserved in that sense since they didn't
Right.
have the information. That's why it became a motion for new trial, and I suggest it's preserved.
And so
in
what
that
is our
sense.
standard of review for a motion for new trial?
That would be
Abuse of
an abuse of
discretion.
discretion, but this, again, if it is structural error, then it is an abuse of discretion not to allow it.
Okay, so I couldn't find, did you find a case where the issue was someone who had been deprived a peremptory challenge because of a juror's failure to disclose pertinent information?
No,
No.
neither this court nor the SJC has directly answered that question.
Of what the standard of review is for that?
That's correct, Your Honor.
Right, so I don't think we can say the standard of review is structural error. You can argue that the standard of review should be structural error.
I'm simply arguing that would be the correct standard of review, and I agree that's not
And that's
correct.
by analogy to the cases where someone who has tried to exercise a peremptory challenge was denied that opportunity and then lodged an objection.
Yes, Your Honor.
That's what you're basing it on.
Yes, that and the general view of the courts of the importance of peremptory challenges. I believe my time's pretty much
Oh, no,
up.
go ahead.
Um,
This is an important case. We're not going to worry
Thank
about
you, Your
the
Honor.
time clock. So let's say that it's not structural error. What then would we be looking at?
If we're, then the question would be,
Or does your whole appeal hinge on the idea that it has to be structural error?
I think it does hinge on that, Your Honor.
Okay, because, so then just help me, because I'm not going to take that as a
Yeah.
detrimental concession of any sort. But let's say that we were going to say, you've raised the argument, so let's say we determine that the standard review is something other than structural error. What would we be looking for? Does it reduce again to the question of whether you showed that the juror was not indifferent?
Yeah, in that case, Your Honor, we go back to the question of whether there was prejudice.
I see. Okay. That's very helpful to
that-
me, by the way.
Thank you, Your Honor. Don't have too much more on that point, Your Honor. I would only say that the Commonwealth has raised Amaralt as the basis for its argument. And I would point out that in Green, Commonwealth versus Green, that's 420 Massachusetts 771, in note 6, the Supreme Judicial Court has explained that that was dicta, that the part of Amaralt concerning peremptory challenges was dicta, and has said that in the Amaralt case, and that the Supreme Judicial Court has refused to adopt a rule that requires a showing of prejudice in order to reverse a defendant's conviction on the basis of erroneous denial of a peremptory challenge.
But was that, again, where the person sought to exercise a peremptory challenge and then they were denied that opportunity?
It was, Your Honor.
Yeah.
This precise issue has not been decided.
Yeah. It's a tricky issue.
Thank you, Your Honor. Any other
Let me
questions?
see if there are any other questions. All right. Thank you
Thank you, Your
both.
Honor.
Attorney Hartley.
Good morning, and may it please the court, Brooke Hartley for the Commonwealth. Before I begin, I would just like to acknowledge some of the victims' family members who are watching on the live stream right now. This court should affirm the orders denying the defendant's motion for a new trial and for disqualification of the judge. And I will just take the issues in turn, starting with the issue my sister raised during the first part of the argument, unless the court has specific questions.
Well, can I just pause you for one moment and ask a specific question, because despite the long argument with your sister, we did not get to the disqualification question. And I just have a practical question, which is, given that the judge at issue is no longer on the bench, what is the need, or what would be the practical result of our deciding, just assuming arguendo, that disqualification was appropriate? Won't it go back to someone else anyway?
I believe so. I believe that would be the only practical option, Your Honor. But I of course, would argue to the court that the judge properly denied the motion for disqualification, where there was absolutely no issue of prosecutorial misconduct before.
Sorry, no, don't get me wrong. That was a question about us, not you. I'm not suggesting that you just failed to brief something. It doesn't matter.
Yes, Your Honor.
Well, so let's go back to the beginning. It seems undisputed that the half brother is incarcerated and he taunts the defendant and he says, "That's why my sister convicted you." Right? Is that undisputed?
Correct, Your Honor.
Okay. Can you give me an explanation for that is innocent? Because I'm
So-
really struggling on it.
I understand, Your Honor. I don't think the Commonwealth, or it really matters why he or how he had that information, because based on the factual findings that the motion judge found, we know that the juror did not speak to him for the entirety of the time he was in jail, and in fact only found out about this.
Well, somebody spoke to him because he was incarcerated when he made the taunt.
Sure.
Okay,
but
so she could have said, "I was on this trial and this was the victim and here's who we convicted." And then she wouldn't have said that apparently to the brother. She would have said it to some other family member who had thought it apparently was juicy enough to go to prison and visit him and tell him.
Sure, Your Honor. In that hypothetical situation, with those speculative
Well,
facts,
either she told him or somebody else told him, right?
well, we know she didn't tell him. I suppose it's possible that she told someone else who told him, but because the critical inquiry here is whether that juror was impartial, it doesn't matter if someone else told him or who he found out from, because we're just focused on this juror and whether she had an intent to deceive the court when she answered that question inaccurately.
Right. So I don't want to get into whether this was a lie or not a lie. I don't find that productive, but the defendant has used the expression positive non-disclosure. In other words, she knew that her brother was incarcerated for a crime. She knew the question was asked and that the answer to the question was yes. And she then decided not to answer yes. Is that also, do you agree with that?
I'm not sure I would phrase it in that way, that she then decided not to answer that. I think it's absolutely correct based on the record that her answer was inaccurate. But I don't think inaccurate equals dishonest, or inaccurate equals an intent to deceive the court. And I think if you look at McDonough, where although
It wasn't Judge Henry's question exactly. Judge Henry asked you whether it's whether the evidence was that she knew at the time that she wasn't disclosing what was asked for.
so she knew at the time that Carl Baxter Jr., her half brother, was incarcerated.
Right. And
I'm
she knew the question, obviously.
Correct. But
Right.
I'm not sure we can say that she was intentionally answering the question dishonestly. even
Well,
though
in the way that, no, I mean, she was intentionally answering it incompletely. In other words, she did not disclose information that was called for. And now, but it seems to me fundamentally the question is, what is the motivation for that? Because if the motivation is embarrassment, let's say, about a family member's situation, that might be one thing. If it's because she wants to hide that she has a connection to these gangs, it would be another thing, right? We would feel differently about those two
Yes.
facts. So what was the evidence here of motivation?
So the evidence, I think if you look at the testimony from the hearing and you look at Judge Fabricant's findings, which we accept unless the court finds that they're clearly erroneous, what came out at the hearing, and I'll just go through the facts briefly if I may, was that the juror was aware that Carl was incarcerated at the time of the trial because of the newspaper article she had read. Between the time she read the article and the beginning of the trial, she didn't learn anything more about his gang affiliation or a connection between that gang and any gangs related to the defendants or victim at trial.
The article was in 2007.
Yes.
The trial began in April of 2010.
Correct. She was not aware that, I briefly touched on this, but she was not aware that Carl was affiliated with any gang with a connection to the case. She had no contact with him while he was incarcerated. She did tell him she was on trial for murder for a murder case after the trial was over, when they sort of rekindled their relationship. And the
Not
judge,
after the trial was over, after he was released from prison.
and after the trial was over, is when she told him that she had served on a murder trial.
Well, when did his incarceration end?
I'm not sure when it ended, Your Honor.
Okay, so when you're saying after the trial ended in May of 2010.
Yes.
He was still in prison.
So it probably was because her testimony was also that she didn't speak to him while he was in prison. I would assume it was after he was released.
Right,
Yes.
so that's why I'm trying to straighten out what you just said.
So I don't think there was a finding to that effect and based on the testimony, but it logically makes sense.
Well, we don't know when he was released from jail.
No, but we know that she didn't speak to him while he was incarcerated, and we know that she didn't tell him about the trial until after it happened.
So we also know the judge said it's not for you to determine whether this is relevant and that she disregarded that, correct?
So again, I don't know that I would characterize it as her disregarding it. I think certainly it doesn't seem from our perspective rational for her to answer the question that way. But again, I don't think that's the inquiry. And I think if you look at McDonough power equipment and what the court says there about how we look at jurors answering these questions, the court specifically says that jurors are not necessarily experts in the English language. They're from all walks of life and maybe uncertain.
Any indication that English was not her first and only language?
I don't take it literally to mean
okay.
don't understand English language. I think in general, maybe terms of art
Well,
can
I'm
get
not sure.
lost.
What's the term of, it's not for you to determine the relevance. I mean, the judge specifically said, answer this accurately, even if you think it's irrelevant.
Sure. And objectively speaking, that was an inaccurate answer. But I think based on the judge's findings and based on the judge who had the opportunity to observe her
Okay,
demeanor.
so going back though, is the finding that that the accurate disclosure would not have given rise to a viable challenge for a cause, is that a mixed question of fact and law, or do you think that's a question of fact?
I would say it's a mixed question of fact and law, but I think if you look at the facts and how the judge applied the law to those facts, there's no abuse of discretion here, and there's certainly no clear error in her findings of fact.
Well, there's a fundamental, I mean, we need the system to have integrity, and there's a fundamental concern here, particularly given the treatment of other jurors about whether that the system has integrity here. And nobody lightly would ever want to overturn a murder verdict or an 8-week trial verdict. But we have somebody who has a family member who was in a gang in the area in question, who may have been on at least positive terms with the victim. Does that not cause you any concern?
When you put it that way, it sounds concerning, but when you really look at the facts that came out at this hearing, that this person had no relationship with her half brother at the time, and that if she had answered that accurately and further questions had been asked, essentially no more information would have come to light because she didn't know anything more.
Why do we ask people to answer these questions? Because and it's not just from this case. We've got many cases where we know jurors struggle to answer this question. It can be embarrassing and worse. So why, but we keep asking. So why do we ask? What's the purpose of that?
Because I think we're trying to uncover juror bias, Your Honor.
Right. We think the information is relevant and we think the jurors should not be making that determination. We think that more than half the time, the Commonwealth is the one who's wanting this information.
Absolutely. But the critical inquiry is whether this person was impartial. So again, it's a two-part test. The first part being whether the juror failed to answer the question honestly. And the court has said that if a judge finds that the juror answered the question mistakenly, but honestly, the analysis stops there. If not.
Right. But I understand in a case like Amaral, where she says, she was apparently abused as a child, and she says she's blacked it out and she didn't remember. That seems very different from this case, because this case, we're guessing as to what first of all, we're only on a preponderance standard, right? Even under Amaral.
Correct.
And we're frankly guessing about what her motivation was. You're looking her in the eye, but if she's the best liar in the world, we got nothing. She's just saying, yes, I knew I answered inaccurately, but somehow we're going to disregard that and decide she's answering this other question accurately.
So I disagree with that characterization because again, you have the first part of the test. And even if the court finds that she answered dishonestly, we move on to whether there was prejudice.
How would someone prove that? Would she have to just post on social media, wow, I really, convicted this guy? I mean, what would satisfy that?
It's a credibility determination that the judge at the hearing makes in person. And obviously there's a reason why the standard for those factual findings is clearly erroneous, because the judge has the opportunity to observe her demeanor and to determine whether she's a credible witness. And here the judge found that she was a credible witness.
But I'm back to the integrity of the system. Okay. Which to me seems to be a first principle point. And so now what you're saying is we've set up a test. I just want to be clear. I'm not being judgmental. I just want to make sure we're clear about this. We've set up a test where the judge says this person made a purposeful non-disclosure, but I can still find them credible.
Again, I disagree with the characterization that it's a purposeful disclosure. I think it's a mistake, a misunderstanding.
I thought you agreed at the beginning it was a positive non-disclosure.
It was, if I agreed to that, I would characterize it as an inaccurate answer, a misunderstanding of the question.
Why is it? You've lost me how this is a misunderstanding. The question asked.
I'm sorry to interrupt, Judge Henry. At the hearing, the witness explained directly why she didn't answer the question. And she said it wasn't relevant. She didn't say, I didn't understand the question. I had forgotten the information. So we're just going to take it that it was that she chose not to answer. She chose not to provide the information that was requested.
Well, I think her answer that I thought it wasn't relevant is a type of misunderstanding of the question.
Well, but I don't know, but I have a couple of different questions for you.
Sure.
At the time the juror filled out the questionnaire, what did she know about this case?
There's nothing in the record to suggest that she knew anything about the
Ordinarily,
case.
when is the questionnaire completed?
I believe before the trial starts.
Right. I do think there is something in the record that would indicate that they didn't know, none of the jurors knew what the case was about because they had completed their questionnaires before they were brought to the courtroom.
Yes, Your Honor.
All right. Once she's falsely, well, I won't use falsely. Once she's not disclosing the information to the judge during the sidebar conference, even though the judge has given a pretty lengthy, like 2-page explanation about that specific question on the questionnaire and how it was important to disclose all information, even if you think it's not relevant. So at the time she's at sidebar in the voir dire, and she doesn't disclose the information, what does she know about this case?
I don't believe she knows any of the facts of this case at that time, Your Honor.
So she knows actually a little bit.
Okay.
She knows the names of the defendants.
Correct, yes.
She knows that it involved a stabbing. She has the names of many, many witnesses, but I note that no one's claiming that she knew any of these witnesses. I mean, there were like dozens and dozens of witnesses. And she knows that it took place on Havelock Street.
Right.
The
where she
date
lived, yeah.
that each of the 4 defendants are accused of stabbing to death Terrance Jacobs. And I believe when I read through this, that she also knew that there was some a contention that it might have been involved retaliation among groups.
Yes, Your Honor.
Okay, so does the fact that she knows something about this case when she decides not to further disclose any information to the judge during voir dire shed any light on what her possible motivation might have been?
I don't think so, Your Honor.
Why not?
Because once the judge questions her at the hearing in relation to Carl Baxter Jr., the evidence that comes out there is that she knew nothing about him or his gang affiliation. She knew the name of the gang because she read it in the article, but she did not know that there was any connection to the trial or any connect, and she did not know any gang evidence relating to the defendants in this trial.
I'm going to throw a couple of legal propositions at you that I don't know if I'm right on. I don't believe the test is whether a viable challenge of cause means whether the defendants or a party would have challenged for cause. We don't.
No, I think it's
reverse. It has to be whether the judge would have allowed the challenge for cause.
I agree. I think it's a valid basis.
Do you think that that's a subjective or an objective test? I think it has got to be objective.
I would agree that it would be objective.
Okay. So, and so the judge's findings, the subsidiary findings on motivation, for example, I think those we accept. But then we are applying an objective test to whether the juror, should have been excused for cause, or is it would have been excused for cause? If it's an objective test, I think it's should have been excused for cause.
I think that would be correct if we're considering it
Okay.
an objective test, which
So try this one on for size. Juror has a half brother who's been convicted of a stabbing crime in a gang context. The case on trial is a stabbing crime in a gang context.
So I think it would depend on that juror's relationship with that person, and that juror's knowledge of the stabbing crime. And I think here, if the facts that came out at the testimony were different, then we would have had a different result. But even if you get past the first prong, which I know we moved on from, but whether she answered honestly, even if she did intend to deceive the court, a correct response would not have provided a valid basis to challenge for cause. So I think the question, the analysis really ends
To
there.
challenge for cause or to excuse for cause?
You know, McDonough, I believe, says challenge for cause.
I know it does. And I think that if that test is correct, then it's a very weird, if that language is correct, it's a very weird.
But I would distinguish valid basis to challenge from the standard my sister was arguing. I think a valid basis is different than the defendant just choosing to
Right,
make a
because
challenge.
all of the cases, even when they duplicate that language, they always look at it in terms of the judge's decision making. They don't look at it and just say, oh, the defendants would have challenged for cause, therefore we reverse the conviction.
I think that's probably right. I think that's
Right?
a more
So
precise.
whatever the language used, when it's later applied, it's applied to, I think, to reflect some assessment of the judges.
I think that's a more precise way to put it, which I know you said, Your Honor said is articulated in the First Circuit civil case you mentioned.
So your opponent points out that McDonough is a civil case. This is a criminal case. What do you say to that?
So I think the Supreme Judicial Court and this court have adopted that test from McDonough in many criminal cases. I don't think that's an issue here.
Yeah.
And I would also just note what happened in McDonough. The question there was whether you or any family members had an injury that resulted in a disability or prolonged pain or suffering. The juror apparently believed that her son's broken leg sustained as a result of an exploding tire was not an injury that resulted in disability or prolonged pain, which I would suggest is objectively an inaccurate answer. But the court again there found that despite this failure to answer the question accurately, the defendant was not entitled to a new trial.
So you go. What do you think is the relationship between the McDonough inquiry and the standard for a new trial?
So you're asking, we review the McDonough inquiry. This court reviews McDonough inquiry for whether there is a clear showing of abuse of discretion or a finding that facts were clearly erroneous. So the standard for a motion for a new trial is abuse of discretion also. I'm not sure.
No,
I'm fully understanding.
I wasn't clear. What is the relationship between the McDonough inquiry and the standard of new trial for the motion judge, for the trial judge?
I'm still not sure I'm understanding.
Okay, so if the judge finds that the McDonough standard has been satisfied, does that mean that the standard for a motion for new trial has been satisfied too?
Yes, I think so,
Okay.
Your Honor. Yes.
So they're coterminous.
Yes. Yes. That would be the Commonwealth's position.
So in Amaral, it seems the SJC was distinguishing a case called United States ex rel Davida, where the court was basically explaining that where the juror was aware of his victimization, whereas in Amaral, the juror was not, and the juror purposely concealed his experience. And they seem to be saying, well, that's a different situation than this case. So what do you, so I guess then I'm asking why Amaral would still control here.
Yeah. One thing I would note in Amaral is that the juror certainly said that she didn't remember the incident at issue, but there was an offer of proof made about a conversation between the juror's attorney and a clerk where the attorney mentioned that the juror had been involved in a sexual assault incident as a youngster, but she didn't recall the details. So I would suggest that she knew that it happened, but she didn't recall the details and therefore answered the questionnaire as she did, which I don't think is all that different from this case. Again, it's an inaccurate answer, no matter how you slice it. And the court analyzed the motivations and found that there was no bias there and there was no prejudice. And I would agree with the court that I think Sampson actually, I know this is not the controlling case, but I think the facts of Sampson are completely distinguishable from this case and actually support the Commonwealth's position. Because there you had a juror who intentionally and repeatedly answered a series of questions the court found dishonestly, and did so in an effort to avoid disclosing and discussing an experience with her ex-husband and her daughter that was very painful to her. And that much was obvious from her physical behavior at the hearing. So I think it's very distinguishable from this case.
So here it seemed like, and I don't have the specific language, but the juror seemed to sort of indicate she didn't want to be involved or know about that nonsense, meaning the gang activity. And so the defendants are arguing, well, if she had that view about gang activity, that really would have indicated there was bias one way or the other, maybe not having anything to do with the specific facts of the case, but that she didn't like gang activity.
Yes, and I think defense counsel tries to compare that to Sampson, where there was some evidence that the juror was embarrassed, not only very distressed over it, but embarrassed. I think that's entirely speculative here based on what came out at the hearing. I don't think we can infer based on the fact that she said she has nothing to do with that, that her reason for that, saying that, or her reason for not disclosing that information to the court was because she was embarrassed. I think that's
was there separate voir dire questioning that about beliefs about gang lifestyle? I mean, if she had said, I don't approve of people who are in a gang lifestyle, would that have been an issue in voir dire?
I'm not sure, because I disagree with defense counsel that there was gang evidence at trial. I think this was specifically discussed before trial. If you look at the first day of trial, page 15, the judge said, we're not going to have evidence of gang affiliation here. There were references to MOB as a group. They were very careful not to talk about it as a gang. And there were references to the streets where various groups of people lived. But I think the evidence came in carefully and not as gang evidence. There was no evidence of retaliation between gangs or gang motive or anything like that.
One thing that was unclear to me from the record is I saw the investigator's affidavit. What I didn't see were actual copies of whatever the postings were on social media. Were those exhibits during the Fiddler hearing?
Your Honor, I apologize. I
Okay.
don't know off the
So
top of my
here's
head.
what I'm going to ask, and the parties can just work together on this because it shouldn't be controversial. If there were exhibits during the Fiddler hearing, so in other words, I don't want you to give us something that wasn't in the record for Judge Fabricant. But to me, I couldn't find in the appellate record copies of whatever these communications on social media were. We don't get to look at them if they weren't actually introduced down below. So I'm not inviting some extra record submission. I want to make that clear. But if they were, would you please consult, agree on what they are and submit them to the court in a letter?
Yes, Your Honor.
Okay. And on Faria, I'm only going to ask the defendants to file limited to 5-page collectively to talk about that case. I don't see a need for the Commonwealth to respond, but if you look at their response and feel that you need to just file something.
Okay. Thank you, Your Honor.
Again, if you do 5 pages, no more than 5 pages.
Okay. Yes. I see that I'm well over time, but would the court like me to address the peremptory challenge issue briefly?
Sure.
Okay. So as this court knows, there's no constitutional right to a peremptory challenge. I think my brother is arguing that there's a statutory right. And Justice Wolohojian, you sort of addressed this already, but that right really protects the erroneous denial of a peremptory. And from my reading of the case law, that can happen in one of two ways. That's either when a a party tries to exercise a peremptory and a judge errs in finding it improper, or when a judge improperly refuses a challenge for cause, and then the defendant uses a peremptory, later runs out of peremptories and argues that should have been entitled to have a peremptory that he lost improperly earlier, or she. So here the defendant is simply alleging a denied opportunity to use a peremptory challenge, which is qualitatively different. I agree that I haven't found any case law.
Yeah,
where
but
this
it's
is-
gotta be that, it reduces to the same test, because you really couldn't place on the defendant a burden to preserve the denial of a peremptory when the information upon which that peremptory would have been exercised was not disclosed. I mean,
So
that
if
would be
that's the
nuts.
case,
And also, I assumed, because no one raised it, but if anyone thinks it's pertinent, you can submit this in a letter. I assume that at the time, my reading of the record was such that at the time this juror was seated, the defendants all had peremptories remaining to them.
I did check that,
Yeah.
and I believe they did all have
Okay.
peremptories remaining.
And we don't need a letter.
Okay. Back to the standard we look at this through. Even if, so first of all, I think because this is not a constitutional issue, it's not about fairness. It's simply a requirement. It's a rule. It's in Rule of Criminal Procedure 20. And it's just a very matter of fact rule about peremptories being allowed. It's not an issue of fairness. So I don't think the analysis is the same as those two situations that I just laid out for you. And furthermore, I think that counsel would have to have some basis in the record that trial counsel would have used a peremptory. I don't know if that comes in the form of an affidavit from trial counsel saying, if this juror had answered the questions accurately, I certainly would have used a peremptory. I think in this case, it's speculative that would have happened. We don't have anything in the record to support the fact that Mr. Ortiz or any of the other defendants knew who Carl Baxter was before trial. My brother points to something in the record that he knew of him later on, but if you look at that, that's at Mr. Ortiz's addendum, page 36. It says that there was conflicting evidence about whether he heard of him in 2018 or in 2013, so after the trial. So I don't think there's anything in the record to suggest that counsel would have exercised a peremptory challenge.
Do you have any questions? Do you have any questions? All right, I don't see any further questions. I want to thank counsel, all counsel in this case. This is a very difficult case. The issues present a lot of complexity. We have been helped by your arguments today. We have been helped by your briefing, and we look forward to the subsequent submissions as well. With that, the case is submitted, and we're going to stand in recess for the day. I want to thank Court Officer Harrison and our other court personnel for their help today, and the court is in recess.
Thank you, Your Honors.
What should we say?